All right, so what case are we calling first, Miss Maycomer?
Your Honor, if you can call Isaiah Perry first.
All right, Mr. Perry. Okay. Right, so we're on the record in docket 26000835. That is people of the state of Michigan versus Isaiah Perry. Appearances for the record, Ms. Maycomer.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
And
Good morning, Your Honor. Andrea Lacey, Assistant Public Defender, appearing on behalf of Mr. Perry. Mr. Perry is currently incarcerated in the Eaton County Jail. Was supposed to be writ over this morning, but he is not here. I don't believe that writ was completed.
I can look in the file. I don't think the writ was done, and I know that Eaton County, I'm pretty sure they don't allow a polycom.
I don't think they do either.
Yeah. All right, so I have that we adjourned last time, good cause for writ defendant out of Eaton County, and then the writ was not complete for whatever reason. Ms. Maycomer, how did you want to proceed today? I assume that we could adjourn this for good cause and re-writ Mr. Perry out.
Yes, Your Honor, that would be our preference.
Yeah. So we'll make sure that the writ's done. I don't know why it wasn't done. But we'll writ. So we'll adjourn for good cause. Because it's not Mr. Perry's fault he's not here.
Thank you.
And we will writ out D from Eaton County. And we'll schedule a new date for preliminary examination for
May 22nd at 10.
May 22nd at 10 o'clock. Let's make sure that's all right. So that should give enough time for the writ to go through, and May 22nd at 10 o'clock. And Miss Maycomer to have enough time to subpoena her witnesses. So we'll adjourn for good cause for preliminary examination to May 22nd at 10 o'clock. Anything else for the record in 26000835, Miss Maycomer?
Not from the people, Your Honor, but defense one would just bond, even though defendant is not here.
All right, Miss Lacey.
Thank you, Your Honor. Yes, obviously my client is not here. However, him and I have had extensive conversations about this case. He is currently on a PR bond, but serving time in Eaton County Jail.
Right.
It's his desire that he be given a bond that would allow him to accumulate time on this case. So we'd be asking for, I think his bond right now is a $2,000 PR bond, a $2,000 10% bond in this matter, so he can at least accumulate time.
Any objection to the $2,000 10%, Miss Maycomer?
No, Your Honor.
All right. I'm going to modify the bond to read $2,000, 10%. So Mr. Perry can accumulate any time he has on this file also. The previous bond conditions remain, so no assaultive behavior, no use of drugs or alcohol without a prescription, no out-of-state travel, no possession of firearms or dangerous weapon, and no use of marijuana. That was set by the magistrate, and report to pretrial services within 48 hours of his date is released. Those are set as pretrial conditions for his 2010% bond. That was originally a PR bond. Anything else for the record in 26000835, Miss Lacey?
No, Your Honor.
Miss Maycomer?
No, Your Honor, thank you.
All right, you should be all set. I'll see everybody on May 22nd at 10 o'clock.
Thank you.
Thank you.
All right, Mrs. Maycomer, where are we going now?
Aaron, if we can do, Mr. Jones, the Danielle Jones.
Dinell Jones. All right, so we're on the record in docket 26-01043. That is people of the state of Michigan versus Dinell Jones. Appearances for the record, Ms. Maycomer.
Good morning, Your Honor. Natalie Making on behalf of the people.
Mr. Sarts.
Good morning, Your Honor. Jacob Sarts, the fourth Assistant Public Defender here on behalf of Mr. Jones. Mr. Jones is present at council table. He's standing to my right.
And sir, you are Dinell Jones, is that correct?
Yes, sir.
All right, thank you. This is the time set for preliminary examination today. Ms. Maycomer, how are we proceeding?
Thank you, Your Honor. It's my understanding that both the people and the defense will be unconditionally waiving the right to hold a preliminary examination in this file. We'd ask that the matter be bound over to the circuit court on the charges in the complaint. For the record, Your Honor, there is an offer that has been extended to Mr. Jones. That offer is for Mr. Jones to enter a guilty plea to dismiss count 1, enter a guilty plea to some of the remaining counts. Those negotiations will continue in circuit court.
Okay. And is that your understanding, Mr. Sarts?
That's correct, Your Honor. And Mr. Jones is agreeing to waive up on the current charges, but it's my understanding of the circuit court that Mr. Berman, prosecutor, is willing to at least dismiss count 1, and then we'll continue our negotiations up the circuit court.
All right.
Thank you.
And may I inquire of Mr. Jones of his waiver of the preliminary examination?
Yes, please, Your Honor.
All right, Mr. Jones, you understand you have a right to preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You were represented today by attorney Jacob Sarps, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It's my understanding that it is your wish to waive your right to preliminary examination. An offer has been placed on the record concerning the dismissal of count 1, and then negotiations are continuing on the other counts. Is it your wish today to waive your right to preliminary examination?
Yes, sir.
To the people, I think the previous, Ms. Maycomer, you indicated that the people previously indicated that the people choose to waive their right to a preliminary examination.
Yes, Your Honor.
I find the waiver of the preliminary examination being knowing, voluntarily, and accurately made. And I will provide the bind over documentation for signature purposes. Put this on David's resume and have everybody sign it. Thank you, Mr. Walms.
You're welcome, Judge.
All right, so I'm in possession of the bind over documentation on 26-01043, signed by all the parties. I'll indicate the examination has been waived on today's date, which is May 8, 2026. Bond is set in the amount of $20,000. It is a PR bond. Anything else to come to the court's attention before I sign the bind over documentation, Ms. Maycomer?
No, Your Honor. Thank you.
Mr. Sarts?
No, Your Honor. Thank you.
All right. I will sign the bind over documentation. Your time in district court is done. You're off to circuit court, where you get your next date of appearance in circuit court from your attorney, Mr. Sarts. All right, Mr. Jones?
Okay.
All right, you're all set, sir. Thank you for your appearance today.
Thank you, Your Honor.
Thank you, Mr. Sarts. All right, where did you want to head to next, Miss Maycomer?
We could do Mr. Cleve Mitchell.
Okay. All right, so we are on the record in docket 25-030 2503-496. That is People of the State of Michigan versus Khalid Mitchell. Appearances for the record, Ms. Macon.
Good morning, Your Honor. Natalie Macon on behalf of the people.
Mr. Sarts.
Good morning, Your Honor. Jacob Sarts, the fourth assistant public defender here on behalf of Mr. Mitchell. Mr. Mitchell is present at the council table. He's standing to my right.
And sir, you are Khalid Mitchell, is that correct? Yes. All right, thank you. This is the time set for a preliminary examination today. Ms. Macomber, how are we proceeding?
Thank you, Your Honor. The people and the defense will both be waiving the right to hold a preliminary examination in this matter. We ask the case bound over on the charges in the complaint. While there is no offer to place on the record as far as the charge itself, Your Honor, the people would like to address a bond issue, not modified bond. But part of this waiver, the agreement is that the people will not be seeking to add witness interference charges.
So no additional charges
Yes.
as a part of. As a part of the offer. Is that your understanding, based on the record, Mr. Sarts, that the defendant is willing to waive his right to preliminary examination with the understanding that no additional charges are being sought on the matter by the people of the state of Michigan?
That's correct, Your Honor. And it's my understanding that the people are going to be asking essentially for an admonishment. I'm just going to be requesting that Your Honor continue Mr. Mitchell's bond with this warning taken and of course very seriously by Mr. Mitchell and his family.
All right. All right. May I inquire of Mr. Mitchell of his waiver of the preliminary examination, and then once we get through that, we can talk about the being designated to file the pretrial conditions.
Thank you, Your Honor.
Mr. Mitchell, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing, which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Jacob Sarts, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to a preliminary examination, have this case continue to circuit court, where negotiations are going to continue in circuit court, and there will be no additional charges brought by the people of the state of Michigan. Is it your wish today to waive your right to preliminary examination?
Yes, sir.
Ms. Macomber, did the people also waive their right to preliminary examination?
Yes, Your Honor.
I find that the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I'll provide the bind over documentation for signature purposes, and then we can address any modification of bond. All right, thank you, David. All right, I'm in possession of the bind over documentation on docket 2503-496. It's signed by all the parties. I'm going to indicate that the examination was waived on today's date, which is May 8, 2026. A bond has been set in this matter. Ms. Macomber, you weren't asking for modification of bond, but you were asking for for the bond to be recognized or to be designated concerning the prior, and I'm not aware of any.
Yes, sure.
But there have been some, maybe some discretion, and the people have some concerns, so you can make a record.
Thank you, Your Honor. Your Honor, speaking with a victim this morning, Ms. Mariah Merrill, she advised me that members of Mr. Mitchell's family have been reaching out to her. They've been reaching out to her in threats of fighting with her, harassing her, and in those contacts are representing that Mr. Mitchell is requesting or at least encouraging those contacts and threats. So we've asked the court admonish Mr. Mitchell that even if he himself is not the person directly contacting the victim, if he is directing others to do so, or if others are doing so on his behalf, he could be held in not only contempt, but additional charges such as witness interference or witness tampering could be sought against him. As we'd ask the court to admonish Mr. Mitchell and ensure that he understands that, so that way there are no future issues.
All right, thank you. And is that a fair statement, and anything you'd like to see on the record, Mr. Sarts?
Thank you, Your Honor. I would note that Mr. Mitchell obviously is not telling his family to do any of this. Mr. Mitchell understands the seriousness of the no contact order. He has been complying with Your Honor's bond conditions. His immediate members of his family are here. They understand the seriousness of the allegations, but Mr. Mitchell does have a large and extended family. The message is well heeded. The warning is well heeded. Mr. Mitchell hears it loud and clear, Your Honor, and respectfully, Mr. Mitchell and his family will make sure that there's no future allegations like this as we proceed.
All right, thank you. The no contact order stays in effect. It is direct or indirect, which means you can have no direct contact, or nobody should be contacting Ms. Mitchell on your behalf. So that would go to your extended family, anything else. It appears, Mr. Mitchell, that the complaining victim has at least complained to the prosecutor that she's been contacted by members of your family. Regardless, it's just a bad idea. Okay, whether your members of your family are whether you're telling them this, which your Mr. Sarts indicates you are not, or whether they're doing it on their own, it has to stop. Okay, because the prosecutor will continue to get complaints, and it'll come back, and you're the one who's going to suffer because you have the no contact order. So we will readdress that there is no contact order. It is direct or indirect, and that means that none of your family members or friends should be contacting Miss Mitchell.
Miss Merrill, Your Honor.
Miss Merrill. It's Maria K. Merrill. Okay. All right. Your time in district court is done. That the no contact order goes into circuit court. You'll get your next date of appearance from your attorney, Mr. Sarts, in circuit court. All right, sir? All right. Anything else for the record before I sign the bind over documentation on 2503496 of Ms. McMacomer?
No, Your Honor, thank you.
Mr. Sarts.
No, Your Honor, thank you.
All right. I'm going to sign the bind over documentation. You should be all set, Mr. Mitchell. Thank you.
Thank you, Your Honor.
Thank you, Mr. Sarts. And then, do we still have this arrangement? We have both files, but. So Ms. Maycomer, if you want, we're supposed to do an arraignment, but I don't know if he's here. Yeah, it's Mr. Bullion. Is Mr. Bullion here or his attorney? All right, then forget it. How's that? Because and then if you want to proceed, or if you need some time to talk, just let me know.
Mr. Leha, we're just waiting on him to get brought up, Your Honor.
So Mr. Leha needs to be brought up.
Okay, got you, sir.
All right.
We can do Abba Adam while we're waiting.
All right, Abba Adams. Abba Adams. Wanji?
Oh, you're gonna make it Mr. Moore after.
Okay.
Adam's downstairs.
Oh, he's downstairs. Can we do Mr. Moore now? Was Moore downstairs?
I don't think so. He should be over Zoom, but he may have refused.
Oh, that's right. We can do Mr. Moore. That's right.
I just don't know where is Mr. Moore is. I've got Mr. Moore in custody.
Correct.
Okay, but he's not, I don't have anybody on Polycom.
Yes, that's usually correct. He's been refusing
Okay.
to come to court.
Oh, okay,
Yes.
I know Mr. Moore. All right, let's do Mr. Moore. All right. All right, so we're on the record in 25-03834. That is People of the State of Michigan versus Raphael Moore. Appearances for the record, Ms. McComber.
Morning, Your Honor. Natalie Maycomer on behalf of the people.
Ms. Robinson.
Karen Robinson, Assistant Public Defender for Mr. Moore.
And Mr. Moore, it was indicated to the court, we actually had another arraignment file for Mr. Moore, and we started on that. And then I got an email from one of the LPD detention officers that Mr. Moore refused to leave his cell this morning. With that understanding, Ms. Maycomer, how did you want to proceed today? I think we were treating this as a PCC.
Yes, Your Honor. I'll just go. And April 30th is when I filed a competency petition. I filed it on his other charges as well. So that should be in the works. I don't know if it's made it to the court file, but
I think the competency has made it to the court file, the petition, and it has an order with it that the defendant shall undergo an examination related to the issue of competency to stand trial by the Center for Forensic Psychiatry. Is there any objection to the court signing that order today?
No, Your Honor.
All right, and is that part of the request, Ms. Robinson? Are you requesting the court sign the order today?
I am, Judge. Thank you.
All right, so I'm going to sign the order for competency examination. Today's date, which is May 8th. And then I'm going to indicate on the register of actions that I signed the order for competency examination. And let's set it for a couple, like 60 days, just as a control date, just so we don't lose track of the file. That would be my fear, because all right, so we'll set it out 60 days as a control date for.
It's gonna be on a PCC.
Yeah, it'll be a PCC or prelim date where it's just to make sure we know that the forensic center is doing what they're supposed to do.
July 10th
July 10th
at 10.
at 10 o'clock. All right, so we've set the control date review for July 10th at 10 o'clock. I've signed the order. Anything else for the record in docket 25-0384? Ms. Maycomer, we know where Mr. Moore is. He's simply, so we're waiving his appearance today. Is that correct?
Yes.
Well, he refused, so.
He's just not coming, but we know why.
Right.
Okay. Anything else, Ms. Maycomer?
No, Your Honor.
Ms. Robinson?
No, Your Honor. Thank you.
All right. We're all set on 25-03-834. Thank you, everybody, for your appearance.
Thank you.
All right, so we're bringing Mr. Milk's client up. Yes. Ms. Donnelly's on Mr. Lopez, but I didn't check to see the file. Mr. Perone's on that case too. Is that
No,
correct?
He's substituting.
He's
the
substitute. Okay.
He sent, so that's what Mr. Berman file that I'm also covering for today. He sent Mr. Berman an email yesterday saying that he would be here at 10.
Okay.
So
I don't have on Mr. Lopez, I don't have an appearance. I have an appearance filed by Ms. Donnelly, but I don't have a substitution of appearance, but
I'm checking the files. We got the substitution and it was signed.
all right. So if there's no, so that's on Mr. Lopez, and is there another one or?
Mr. Schaefer, Mr. Butler.
Mr. Schaefer.
Yeah, apparently it was put in the courier to come over to court
All right.
3 days ago, so.
And then, so, and then Ms. Wanji's on Mr. Adam.
Yes, you'll also have to be brought up.
All right.
Online.
So let's So it looks like everybody else has to be brought up except for Mr. Mackey at 8:30.
Yes, and Ms. Patrick is here. I've not spoken with her yet.
All right. So I'll give you a chance to talk to Ms. Patrick. We have Mr. Aaron Schroeder's here for Mr. Taylor, and Ms. Patrick's also here on Mr. Timko, and we have Mr. Leha. Is that correct?
Yes.
All right. That was kind of a organizational. All right. All right, and Mr. Milks, are you ready to go on, Mr. Leha?
We are ready to go, Your Honor. Thank you.
All right, so we're on the record in docket 26-00848. That is People of the State of Michigan versus David Leha. Appearances for the record, Ms. Maycomer.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
Mr. Milks.
Good morning, Your Honor. Stephen Milks on behalf of my client, Mr. Leha, who is present and standing to my right at this time.
And sir, you are David Leha, is that correct? All right, thank you. This is the time set for preliminary examination today. Ms. Maycomer, how are we proceeding?
Thank you, Your Honor. It's my understanding that both the people and the defense will be waiving the right to hold a preliminary examination in this matter. We ask the case be bound over on the charges in the complaint. There is not an offer to be made as far as the charges are right now. However, similar as before, the people are agreeing not to add witness interference charges, and we would like to address a bond issue after.
So no interference charges will be issued. And is that your understanding, Mr. Milks?
That is my understanding, Your Honor, and that's what I've conveyed to my client.
Right. May I inquire of Mr. Leha of his waiver of the preliminary examination?
Yes, thank you, sir.
Mr. Leha, you understand you have a right to a preliminary examination day. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Stephen Milks, and you would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to a preliminary examination, have this case continue to circuit court. Negotiations are continuing, but there will be no interference charges brought by the people on this matter. Is that your wish to waive your right to a preliminary examination today? Is that a yes, sir? Okay. Ms. Maycomer, do the people also waive their right to a preliminary examination?
Yes, sure.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will provide the bind over documentation for the parties to sign. Thank you. There we go. Thank you, David. All right, we're on. I'm in possession of the bind over documentation on 26-00848, signed by all the parties. I will indicate the examination was waived on today's date, which is May 8th, 2026. Before I sign the bind over documentation, is there anything else to come to the court's attention, Ms. Maycomer?
Yes, Your Honor, thank you. This morning, in speaking with the victim in this case, it came to my attention that she received a letter from the Am County Jail. That letter had a different inmate name and number on it. However, the writing was familiar to her as being written by this defendant. We would ask the court remind Mr. Leha that he is not to contact the victim. That includes sending mail from other inmate accounts or calls or messages or any of that sort, and that any further contact may not only result in a contempt charge, but also in additional charges.
All right. Thank you. Is that a fair statement and any record you want to make, Mr. Milks?
We know that that's the people's position regarding the letter and the accusation at this time, Your Honor. I've spoken to my client regarding these allegations at length, and he understands the repercussions should something like this happen again, or if people pursue this sort of charge, Your Honor. My client's current bond, I don't think people are asking the bond be changed, but it's $250,000 cash surety. In addition to that, Your Honor, I believe he also has sentencing coming up on an unrelated matter before this court on the 18th of this month. So we understand the admonishment. I believe my client understands the ramifications and even the potentially greater problems that he could be facing should he do something like this.
All right. So, Mr. Leah, you understand it is direct or indirect contact with Ms. Johns, and so any mailing, anything that comes from anybody you indicate should contact Ms. Johns is unacceptable. All right. All right. So there should be no direct or indirect contact with a Jade Lynn Johns concerning this file, and Mr. Milks has made a record on your behalf that this is only an allegation at this time. However, it just keeps you out of trouble here, okay? And additional charges. Anything else for the record before I sign the bind over documentation? Bond is set at $250,000 cash or surety. Ms. Maycomer.
No, Your Honor, thank you.
Mr. Milks.
No, nothing further, Your Honor. Thank you.
I'll sign the bind over documentation. 8/20/26. So you'll get your next date in circuit court to appear from your attorney, Mr. Milks. All right. Mr. Milks, did you want to address the court?
If I can talk to the prosecutor.
Okay.
Quick.
Judge, just for the record, in speaking with Mr. Milks, there is a potential that there is a second letter that the victim has not yet received. I will make sure that our office contacts the victim and let her know. It's my understanding that that letter would have been dated at the end of last month, that if there's anything beyond that letter itself, we would look at whether or not that would constitute interference. But if a second letter arrives that's dated towards the end of last month, that would not.
All
We
right.
would not put charges on that letter.
So it'd be post dating it as of today's date, May 8th.
Yes, sure.
Okay. All right. Any letter that received after May 8th is going to be problematic. Anything before we'll take into consideration that the admonishment was done on today's date.
And I think it's important, as the people have already told me, Your Honor, that if there is any other communications, that doesn't bar the people from bringing up these two letters here. It's just as of right now, that my understanding is that as long as there's no other alleged communications, they will not be seeking charges on these potential letters.
All right. With that understanding, you'll get your next date in circuit court from your attorney, Mr. Milks. Anything else, Mr. Milks, on the record in docket 26-00848?
I pray not, Your Honor.
Thank you.
Thank you.
I think you should be all set, Mr. Leha. I do have a PA 53 from April 1st. Is that being dismissed at this time?
Yes, sure.
Okay. So the request is a dismissal and admonishment. Right, you're all set, Mr. Leha. Thank you for your appearance today.
Thank you.
And then-
Are we bringing anybody else?
Yeah, I think Adam.
Yes.
Okay, so Abba Adam.
Yeah.
Okay. All right. I'll allow you to talk to Ms. Patrick and whoever else you need to talk to, and then we'll go forward.
Thank you, Judge.
All rise.
in summer if we can or something. When it comes to Schaefer, did you ever get a transfer to this file? Because there's a lot going on here. His developmentally disabled young man, his mom was dismissed.
She's my son's dad.
Melanie? Melanie? Melanie.
Hi, can I just speak with you for 1 second?
I got. Yeah, exactly. And yeah, yeah, process and then let me know what you need.
I ran out here. Yeah. Yeah.
Yeah.
You wouldn't take that.
Yeah, that's what they were talking about. Okay. I guess. And so. Well, not yet. I mean, because. Yes. Oh, just. Let me talk to him first.
Okay.
That's right. I'm gonna talk to him now. So he'll just have to.
Yeah.
Montrell Taylor. Or Montrell Taylor. She's not sure if it's in school.
It is on this. What do you-
Jason Robinson.
yes.
Um,
Oh,
Is I have to talk. Yeah, is she here?
Mhm.
And, is there an offer like that? It's a strangulation, no marks. Is that's stabbing and.
it's all- I just need to-
Yeah,
Yeah, he's from here.
Yeah, we'll talk to him. Me or Jerry's in talking right now.
Sorry. It is. Yes. Oh.
Turns out I forgot I had a PCC in front of me.
Should probably go tell Jamie that I'm here.
Yes, here.
She was here. She was.
I don't. That's not something that to me, but it's just sure.
Questions.
I wouldn't be surprised if I just missed it, but I checked, yesterday when I was reviewing all this, or Tuesday.
Yeah, it's a phone sugar, form.
The electronics.
Yeah,
No, that's going to be just the report.
no, 92 files and evidence.
Oh. Then, all right, let's see. Yep.
Yes, Mr. Adam, you're good to go. On Mr. Matthews, you're good to go, Mr. Matthews cases.
When did he send?
May 4th.
I don't have.
Um,
Okay. Well, like you said, he probably won't wait. Let's bring him up when ready.
and then we can bring Butler.
Three.
Yes.
Are we getting?
Have some.
Waiting.
Okay.
We can, I'm sorry.
Oh.
So I have to wait.
Just resend it.
Yep, she just, yeah.
Okay.
Yep, thank you.
Yeah. Yeah, I even searched by his name and I got yeah. He's saying it's not what I want. And I want. It's his brother, the Saints.
Yeah. Oh, that would be cool. Yeah.
No, hey.
So. you have to piece them together.
Yeah. I'll do
So
it.
there's
I'll
one
get
of them
it.
walking through Frederick, so holding on to the mask, that way you see his face.
Okay.
And then he goes up to Raymond Johnson. Who we originally thought gave him. Huh?
Right.
He did.
Oh, he did.
you told them?
Because who did?
Yeah, they knew.
All right.
What did he have?
You seated. All right. Ms. Baker, where are we proceeding?
Mr. Abba Adams.
All right, so we're on the record in docket 26-00691. That is People of the State of Michigan versus Abba Adam. Appearances for the record, Ms. Maycomer.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
Ms. Swaji.
Good morning, Your Honor. Melanie Biwanji for Mr. Adam, who's by my side at the council table.
And sir, you are Abba Adam, is that correct?
I'm out of here, sir.
Thank you. This is the time set for preliminary examination today. How are the people proceeding?
Thank you, Your Honor. It's my understanding that both the people and the defense will be unconditionally waiving the right to hold a preliminary examination. We'd ask that the case be bound over on the charges in the complaint.
All right. And is that a fair statement, Ms. Swaji?
It is, Your Honor. Thank you.
Okay. May I inquire of your client of his waiver of the preliminary examination?
You may.
Mr. Adam, you understand you have a right to a preliminary examination. Day of preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence the crime is committed and the identity of the person who committed that crime. You were represented today by attorney Melanie Wanchi, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to preliminary examination, have this case continue in circuit court, where negotiations are going to continue. Is it your wish today to waive your right to preliminary examination? The people also waive their right to preliminary examination.
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will provide the bind over documentation for signature purposes to the parties. All right, I'm in possession, thank you, David, of the bind over documentation that's been signed by all the parties. I will indicate in box 3 that the examination was waived on today's date, which is May 8, 2026. There's a PR bond on this file. Anything else for the record before I sign the bind over? Anything come to the court's attention, Ms. Maycomer?
No, Your Honor.
Ms. Wanci.
No, Your Honor, thank you.
I'm going to sign, so your time in district court is done. You're off to circuit court. Will you get your next date of appearance from your attorney, Ms. Wanci? All right, sir? You should be all set, sir. Thank you for your appearance today.
You know, maybe I guess bound. I
You may.
think that he was, bond was revoked last time because he failed to appear in exit 2000.
I have 2,000 cash. Oh, I have bond was set at the arraignment on after the fail to appear at 2,000 cash surety.
I'm sorry, I thought you said PR, but I apologize, Judge.
I did, and I was reading it from they missed the ROA is what happened.
I'm sorry,
Yeah.
Judge.
So bond is set at 2,000 cash surety right now. Cash surety. It was originally a $10,000 PR, and then you had to fail to appear.
Yes.
All right.
Thank you, Judge.
All right. Anything else, Ms. Wanji?
No, Your Honor, thank you.
All right. You'll get your next date from Ms. Wanji. Thank you for your appearance. And Ms. McComber, did you have somebody else you want brought up while David's down?
Yes, Mr. Butler, please.
Mr. Antonio Butler. Yeah, once I read the ROA, I realized they didn't read the ROA. Who did you want to go on next?
We got Mr. Mackey.
Okay, Mr. Mackey's here with Ms. Patrick. And did you want those called together or separately? I think I have two files.
We can do them together, Judge.
All right, 26000176. So we're on the record in 26000176 and 26000544. That is people of the state of Michigan versus James Mackey. Appearances for the record, Ms. McComber.
Thank you, Your Honor. Good morning, Natalie Makeover on behalf of the people.
Ms. Patrick.
Good morning, Your Honor. Melissa Patrick on behalf of James Mackey, who is here to my right.
And sir, you are James Mackey, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination on both files. Ms. Maycomer, how are we proceeding?
Thank you, Your Honor. It's my understanding that both the people and the defense will be unconditionally waiving the right to hold a preliminary examination in this file. We ask that both cases be bound over on the charges in the complaint. There is an offer to state for the record. That offer, Your Honor, was for the defendant to enter a guilty plea to file right now 26176 FY, which is the one count plea in elude third degree. Upon successful plea and sentence, the people would move to dismiss that second file, which is currently 26544 FT. Any sentencing negotiations will continue in circuit court.
All right, Ms. Patrick, is that a fair statement of the negotiations in the terms of the offer that's to your understanding?
Yes, Your Honor.
All right. May I inquire of your client of his waiver of the preliminary examination on both of these files?
Yes, please, Your Honor.
Mr. Mackey, you understand you have a right to a preliminary examination on both these files. You have a right to preliminary examination. The people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Melissa Patrick, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case continue to circuit court where negotiations will continue concerning sentencing, and the offer was placed on the record today. Is that your wish to waive your right to a preliminary examination on file 26000176 and 26000544, Mr. Mackey?
Yes, sir.
All right. And Ms. Maycomer, do the people also waive their right to a preliminary examination on both these files?
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made on 26000176 and 26000544. And I'm going to provide the bind over documentation for signature purposes on 26000176 first.
Commissioner permission
Look
to
at that.
approach, Your Honor?
Yes, I'll let Ms. Patrick will place this on your resume. All right, and then once we're done with that, we'll do it on 26000544. All right, and then I'll trade you on the next file.
Okay.
Thank you, Ms.
No
Patrick.
problem at all.
All right, so I'm in possession. Thank you. On docket 26 of the bind over documentation on 26000176 and 26000544. I'll indicate the examination has been waived on today's date, which is 5/8/2026 on both files. Both files, bond has been set on both files. Anything else for the record before I sign the bind over documentation of Ms. McComber?
No, Your Honor, thank you.
Ms. Patrick.
No, Your Honor, thank you.
All right, you're on to circuit court. Your time in district court is done. You're off to circuit court. Will you get your next date of appearance from your attorney, Ms. Melissa Patrick? All right, sir?
Yes, sir.
All right. I will
Judge?
sign.
Judge,
Yes.
yeah, I just want to say thank you again for the other cases you did for me.
No worries.
I really appreciate it.
And I'm going to sign both. And you should be all set, Mr. Mackey. Thank you for your appearance today.
Thank you.
All right.
Thank you, Your Honor.
All right. So those two are on Mackey. This is Mr. Butler.
Yes, Judge.
And Ms. Donnelly, is this your client?
Oh, yes, Your Honor, thank you. Just a moment
All
before I
right.
go on the record.
Absolutely. And Mr. Carter, what case are you here on?
Next door
Okay.
with Ms. Maycomb.
So you're all over the sixth floor today.
Yes.
When you get a break here, we'll go on there. I tried to get Claire to see, she said she wanted to change in pages that don't work for you.
Thank you.
Okay. All right, thank you, Your Honor, we are ready.
All right, so we're on the record in 26011048. That is People of the State of Michigan versus Antonio Butler. Appearances for the record, Ms. Maycomb.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Antonio Butler, who is standing to my right.
And sir, you're Antonio Lewis Butler, is that correct?
Yes, that's correct.
All right, thank you. This is the time set for a preliminary examination today. Ms. Maycomer, how are we proceeding?
Thank you, Your Honor. It's my understanding that both the people and the defense will be unconditionally waiving the right to hold a preliminary examination in this matter. We'd ask that this case bound over on the charge and the complaint. The offer for the record, Your Honor, is for the defendant to enter a plea to count 1. Upon successful plea and sentence, the people would dismiss the habitual offender third offense notice.
And is that a fair statement of the waiver and the offer as you understand it, Ms. Donnelly?
It is, Your Honor, and I'd like to make a bond request.
All right. So may I inquire of Mr. Butler first of his waiver?
Yes.
Mr. Butler, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Sarah Donnelly, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish to waive your right to preliminary examination, have this case continue to circuit court where negotiations are going to continue. The offer has been placed on the record. Is it your wish today to waive your right to a preliminary examination?
Yes, it is.
Ms. Maycomer, do the people also waive their right to a preliminary examination?
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. I'll provide the bind over documentation for the party's signature.
Thank you.
All right, I'm in possession of the bind over doc. Thank you, David. Docket 26011048, which is signed by all the parties. I will indicate the examination was waived on today's date, which is May 8, 2026. And before I sign the bind over documentation, Ms. Donnelly, you had a motion to make.
Yes, I did. Thank you, Your Honor. At this time, Mr. Butler is being held in Ingham County Jail for this case on a bond that was ordered that he has to pay. It's 2,500, 10% right now, so he would only need $250, but he's been in custody since this arraignment on April 19th, and he has been unable to post that. He reports to me that he does have a Lansing address that he can go to. He has family here. It's an address on Cedar that his sister, right? His mother lives at. So with that, Your Honor, I don't know what exactly the conditions were at arraignment. I didn't know what was also ordered, but Mr. Butler would be would follow any orders the court would give him if they would allow him to have a personal cognizance on it.
All right.
At this point. Thank you.
Ms. Maycomer, anything on behalf of the people? I do have.
No, Your Honor.
All right, I have bond was previously addressed on May 1st by Judge Ward. And then the initial bond was set by the magistrate on this case. Is that your understanding, Ms. Donnelly?
Yes.
Okay. Without indication from the prosecutor, I'm gonna modify the bond. I will not set it. And based on some of the terms of the agreement that I understand, I'll lower the bond, but I'm not going to PR bond it. So I'll set a modification of bond at $1,500, 10%. So it'll be set at $1,500, 10%. I will make that indication in the file that bond is at $1,500, 10%. Anything else for the record in 2601-048, Ms. Maycomer?
No, Your Honor. Thank you.
Ms. Donnelly?
No, thanks.
All right. I will sign the bind over documentation. So Mr. Butler, your time in district court is done. you're off to circuit court where you get your next date of appearance from your attorney, Ms. Donnelly. All right, sir?
Okay.
All right, you're all set. Thank you. Did you want Mr. Wormsley to grab anybody else while he's down? Miss Maycomer, I would.
I have, the only one I eat very is Schaefer, so I still want to figure out what we're gonna do with that, but. Yeah, figure that out first.
Don't, is Ms. Wanji? Is your,
Did you want to bring up Mr. Gorney?
is he in custody? Yes.
No, Gorney's not. in
One is out.
custody.
He
Oh,
bonded
oh,
out.
he made out. Okay.
Okay, then I don't believe anybody else at this time.
All right.
Okay.
No.
Your Honor, did we get Juan Dubois from Eaton? Do you know? if
Tana
we're-
Wandabaugh is, Mr. Wormsley, is Tana Wandabaugh down there on your list? That'd be a writ out of Eaton County, I believe.
She's set for 9:30.
Let's see, and I think we did do a writ in that
Yeah,
matter.
I do remember seeing
Yeah.
it.
What's the name of it again? I'm sorry.
Juan
Yeah,
Dubois. Juan Dubois.
Oh, okay.
Yeah, we did a writ out of Eaton County for today's date. We could bring her up
Yeah, if you want to bring her up, yeah.
if she's down there. Okay.
She was read over last week, so I gotta talk to her soon. Okay, all right. Would you? I know, was it- or is it just a victim? No, you should.
Doyle. Chad Doyle. Is, she is at 30 right now.
Okay, so, and now, and, okay, all right.
And Ms. Maycomer, did you need to go in another courtroom to go on the record?
Yes, if I may, for just one moment, Judge.
You may, just come get me when you're ready, all right?
I'm sorry, thank you,
No,
Judge.
no worries.
All rise.
I thought you and Mr. Carter talking, and so I kind of got the gist of it.
Thank you.
You may be seated.
I'm sorry. I know.
So you want me to? If she's not, we're not done.
No, yeah. Okay, so you know how long?
I don't know what that. It's just next door. I'm just like, and close. Just.
Yes. Yeah, I'm okay with that. So- Right here?
Yeah.
Yeah, they come to get you last week. So, let's see here. So, you go ahead. You got a PR, yeah. Yeah, you got $2,000 PR on this. It's on holding your custody. Okay, so we're set for the exam today. Witnesses did appear. So you wanted to the alleged victim is wearing wire and she was by a deputy.
I don't know what's happening. My dog was- yes, tiny one down. I don't know what happened.
Oh, I know. And see.
What's going on? I got 12 minutes. Wait for 21 days.
So he took.
Isaac will do it? Yeah. All right. So, will there, they don't wait 21 days. So Isaac will do it. Oh, yeah.
I don't know.
I think she's right across the hall.
Oh, yours. Estimates, they said that they put it on the comparable and the cost. But what they did. What your estimate was that.
I know. Kayla Temple's gonna be away from the circuit.
That's a district court in there. Yeah. I haven't.
Oh, it's gonna be a waiver?
Yeah, it's Patrick, I'm sorry.
Yeah.
So Temple's away from us.
Yeah, no.
Just change-
She's, we're asking for an adjournment.
Oh, okay, I
Yeah,
got you.
for her. I mean, for her.
Basically, yeah.
Scared me.
George City, they're still working
And the
on it.
restitution. Exactly. It's basically what they're offering.
Oh, that's on George.
So do you?
George
want
and,
to take
Catherine.
Jay? No, you want to think about
George
it?
is downstairs.
Okay.
Yeah.
You know, you get better. Okay, all right. All right, well, if I can't get that today, it was a good way. Oh, I'm sorry. Anyhow.
Yeah.
And I can't remember. What is? I think you'll see you get. Okay, so there's no probation. Okay, all right.
Yeah.
Well, if you want to do. That's one, yeah. Did you do the PSI, your attorney with recommendation? He didn't know yet. Okay. Okay, who's your attorney? No, okay.
to, if the county releases you,
My God.
And what address you gonna release to? Okay, all right, and what is that? Paper address, okay. It's up to the court, basically, there'll be a short adjournment, long, maybe a week or two. 2 weeks at least, because, yeah, because you have court next week. They want to schedule it either for Thursday or Friday, and then we'll be, that's in court next Thursday, and so we can't bring it back. I know it'll be at least a week. They'll probably set it for like the 22nd or yeah, unless I can get, if I can, if they said they want to do it, are you fine with the offer? If there's no offer, okay. Yeah, yeah. Okay.
How are you?
Because we can.
I'm ready.
Okay.
Yeah, thank you.
So we don't have to delay.
Sorry. Thank you.
Offers and do a P2 would you agree more Joe and Jennifer? So that you yeah, sure. Okay, all right, and choose restitution.
All rise.
Yeah.
You be seated.
Go ahead.
All right, and Ms. McComber, what are we calling first?
Miss Wanda Block.
Yep.
All right.
Probably filling out a clean sheet right now.
All right, so we're on the record in docket 26000796. That is people of the state of Michigan versus Tana Wandebois. Appearances for the record, Ms. Maycomer.
Good morning, Your Honor. Natalie Makeover on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Tana Wandebois, who is standing to my right.
And ma'am, you are Tana Wandebois, is that correct?
Yes, Your Honor.
All right, thank you. This is time set for a preliminary examination in the matter. Ms. Maycomer, how are we proceeding?
Thank you, Your Honor. The people and defense have come to a plea agreement in this file. The defendant will enter a guilty plea as to an. So Judge, do we do it added or amended? Added counts or amended counts?
Let's take a look at the count one. We can just make the count one an amended count.
To amended count one of malicious destruction of property, $200 or more, but less than $1,000.
Okay,
the cat code being 750377A1C1.
and that is a 1 year,
Is a 1 year misdemeanor.
okay, 1 year and or what's the fine on that?
$2,000.
2,000. Is there any sentence agreement, Ms. Bacomer?
Yes, Your Honor, there is a sentencing agreement to no further upfront jail at the time of sentencing. Additionally, the defendant agrees to restitution. That restitution amount will be determined by the sentencing date and provided to the court.
So restitution will be determined by probation. Right, I'll reiterate that for the record, Ms. Donnelly. It's an amended count 1 MDOP over 200 but less than 1,000, which is a 1 year set for November 19th on Walnut and Lenawee pursuant to 750.377A1C1. So 1 year under $2,000. There's a sentence agreement, a Killebrew of no upfront jail, and restitution will be determined by probation. And the defendant, that's all. The restitution to be determined by probation. That's all your understanding, Ms. Donnelly.
It is, Your Honor.
May I inquire of your clients of their misdemeanor vice rights?
You can, Your Honor. I do have a copy signed by the defendant that we've reviewed. I was just waiting on to finish up the plea agreement, but I'll just hand it off to you now, just so you can have it.
All right,
Refer to it.
has your client signed it?
Yes.
All right, so Ms. Wanaboy, you have some jury trial rights in this misdemeanor case. You've signed the bottom of this, is that correct?
Yes, Your Honor.
So I'm just going to go through the highlights, some of the largest constitutional rights. You understand that you have the right to be tried by a jury, to be presumed innocent, to proven guilty, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. Do you understand that, ma'am? You understand if you're please accepted, you'll give up the claim the plea was a result of any promises other than what's been stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be having a trial. You'll be pleading guilty to the MDOP over 200, less than 1,000 instead. Is it still your wish today to waive your jury trial rights and plead guilty to the over 200, under 1,000 misdemeanor MDOP instead?
Yes or no? Or
Yes.
you?
Yes, Your Honor.
Okay. And if you raise your right hand, as best you can, do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. Ms. Donnelly, we'll be taking the factual basis on the underlying count, well, the previous count 1 doesn't matter to me, but well, we'll see. So I'm going to bring your attention back, ma'am, to November 19th, 2025 at South Walnut Street at West Lenawee in the city of Lansing. Were you on November 19th, 2025 South Walnut Street at West Lenawee and in the city of Lansing on that date?
Yes, sir.
And at that time, did you bring injury to a motor vehicle belonging to Rebecca Lynn Wagemaker?
Yes, Your Honor.
All right. And did you do damage to that vehicle? And was that damage over $200?
Or, Your Honor, she doesn't know exactly how much, but I
Right.
guess if the estimated damage was over
All right.
$1,000, so I mean, I usually ask is, would they dispute that?
Do you dispute that that you may have caused damage, or that you did cause damage of over $200?
Yes, Your Honor.
Or wouldn't dispute? Would you argue that the damage is more than $200 or less than 200? No, you wouldn't. Okay, so yes.
We have a lot of double negatives.
It's hard kind of sometimes, yeah.
All right. I will find that as a factual basis that Miss Wanaboy injured a motor vehicle not belonging to Rebecca Lynn Wagemaker in the amount over $200. Miss Wagemaker did not give you permission to destroy or injure her personal property, that vehicle. Is that correct, ma'am?
Did you hear that one?
You didn't have permission to injure or,
No.
okay, all right. That personal property, you didn't have permission?
Nope.
Okay. All right, anything towards the factual basis for the amended count one, Miss Maycomer,
No, Your Honor.
Miss Donnelly?
No, and if I'll approach, I have that plea agreement now
All right.
signed.
Perfect. All right, I'm gonna place the plea agreement. But I think I've written it out. There's a sentencing Killebrew of no upfront jail. I'm gonna refer to probation so that they can determine restitution. If I was gonna do something different than the Killebrew of no upfront jail, you'd have the opportunity to withdraw your plea. Do you understand that, ma'am? Is that a yes?
Yes, sir.
Okay. So restitution will be determined by probation and sentencing. I will, so that's the amended count one, and that's part of the plea agreement. Will she still be in Eaton County for our probation?
She might be, she is sentencing next Thursday.
Okay.
And they're over there, so it's unsure if she will be released or
All
not.
right.
She might be.
So I'm gonna place in the file that you were writ out of Eaton County. You may be out at the time, so you should contact our probation because they're trying to determine restitution.
Okay.
Yep.
So, so if you're out, if you're out, contact probation. If you're still incarcerated, probation will be out to see you, okay?
Yeah, remember.
And then on the, on that,
What,
you do the
you can't give them contact
restitution,
info?
yes.
You know where, they're in this, they're in this, they have to get what?
Yeah, we're gonna set it for sentencing date. On. So it'll be set for June 18th at 9 for sentencing. You may be out by that time, so then come in and see the probation officer. I don't know who's doing the report, but come to probation.
Yes.
Probation's on the 5th floor of City Hall of Lansing, so the one floor down, all the way to your right.
Yes, Your Honor.
All right. Anything is, and I'll see you on June 18th at 9 o'clock. Anything else for the record in 26000796, Ms. Maycomer?
No, Your Honor, thank you.
Ms. Donnelly?
Nope.
All right, Ms. Wandaba, you're all set. Thank you for your appearance
You're
today.
welcome. I'll see you then. All right, I'll call you.
We're all set, just don't need anybody else.
Still
Anyone-
Schaefer downstairs, but
Yes, well,
no.
and nobody else.
No. That was last.
All right, who do you want to call next, Ms. Maycomer?
This is Mr. Lopez next, Your Honor.
Isaac Lopez.
That was my upfront job.
Killebrew, no upfront jail. All right, so we're on the record in docket 2601-042. That is people of the state of Michigan versus Isaac Lopez. Appearances for the record, Ms. Maycomer.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
Mr. Prone.
Jacob Peron on behalf of Isaac Lopez, who's standing to my right first.
And sir, you are Isaac Lopez, is that
Correct.
correct? Thank you. This is the time set for preliminary examination today. Ms. Maycomer, how are we proceeding?
Your Honor, it's my understanding that the defense is going to be asking the court to waive the timeline in order to have the preliminary examination and adjourn this out as Mr. Prone is substituting. And I don't believe he has any of the discovery at this time. People have no objection to that request.
All right, is that a fair statement, Mr. Perone?
It
You
is,
were just hired on the case and
Right.
you need all the discovery so you can zealously represent
Yes, it's
your
my
client.
request.
Okay. I'm gonna grant the request. Are you seeking a waiver of the 21-day rule?
Yes.
All right. May I inquire of your client of the 21-day rule?
Yes, sir.
All right. Mr. Lopez, you understand you have a right to a preliminary examination within 21 days of your date of arraignment. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime is committed and the identity of the person who committed that crime. You're represented today by Attorney Jacob Perone, and you would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish to waive your right to a prelim only within that 21-day period. You wouldn't be waiving your right to a prelim in general, just within that 21-day period. So Mr. Perone can receive discovery from the people of the state of Michigan and zealously represent you in your defense. Is it your wish today to waive your right to a prelim within the 21-day period?
Yes, Your Honor.
Ms. McComber, do the people also waive their right to a prelim within 21 days?
Yes, Your Honor.
I find that the waiver of the preliminary examination 21-day rule to be knowing, voluntarily, and accurately made. And then I think we'd reset it for PCC. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
All right, so we'll reset for PCC and then for prelim. And we'll get a date that works with retained counsel, Mr. Perone's schedule. So the PCC, what's the first date we have for PCC?
Is that, do you want 2 weeks?
It really depends on Mr. Perone's schedule. We need at least 2 weeks for subpoena purposes, I would assume.
Yes, Your Honor.
So
Like, whatever works.
yeah,
PCC May 21st.
May 21st
It's fine.
at 9:30, and then the corresponding preliminary examination. We can wait on that since the waiver of the 21-day rule, we can wait on that. So we've set the PCC after the preliminary, after the waiver of the 21-day rule for May 21st at 9:30. So 9 o'clock or 9:30?
9:30.
9:30, okay. Anything else for the record? So that's when the PCC is set. Anything else for the record in docket 2601-042, Ms. Maycomer?
No, Your Honor. Thank you.
Mr. Perone, do you have any questions?
No, Your Honor, thank you.
All right. All right, Mr. Lopez, we'll see you on May 21st at 9:30. Thank you for your appearance.
Thank you, Judge.
Thanks, guys.
Have, I don't know what that noise is. I don't know. I'm not the person to ask what that noise means. We have Schaefer, Ms. Donnelly.
You can do this Timko versus Patrick.
Okay. Kaylin Timko. Right, so we're on the record in docket 2601-045. That is people of the state of Michigan versus Kaylin Timko. Appearances for the record, Ms. Maycomer.
Good morning, Your Honor. Natalie Maycomer on behalf of the people.
Ms. Patrick.
Morning, Your Honor. Melissa Patrick on behalf of Ms. Timko, who is here to my right.
And ma'am, you are Kaylin Timko, is that correct?
That's correct.
All right, thank you. This is the time set for preliminary examination today. Ms. Maycomer, how are we proceeding?
Your Honor, it's my understanding that defense is going to be requesting an adjournment of this case in order to go over discovery with the client. Therefore, we're asking the court to waive the 21-day timeline. People have no objection.
And is that a fair statement, Ms. Patrick?
It is, Your Honor.
May I inquire of Ms. Timko of the waiver of the 21-day rule?
Yes, please, Your Honor.
Ms. Timko, you understand you have a right to preliminary examination within 21 days of your date of arraignment. Preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Melissa Patrick, and she would be present to cross-examine any witnesses or contest any charges at the prelim. It is my understanding today is your wish to waive your right to a prelim only within that 21-day period. You'd be waiving your right to a prelim only within that 21-day period, so you wouldn't be waiving your right to a prelim in general. And the reason for that is so Ms. Patrick can go over the terms of the agreement with you. If the terms of agreement with you and Zelsi represents you in your defense. Is it your wish today to waive your right to a prelim within the 21 day, within the 21 days? Ms. McComber, do the people also waive their right to a prelim within 21 days?
Yes, Judge.
I find the waiver of the 21 day to be knowing, voluntarily, and accurately made. And should we reset for PCC or do you want to go right to prelim?
Right to prelim.
Okay. So we'll reset for prelim.
May 28th at 10.
And does May 28th at 10 work for your schedule?
At what time?
10 o'clock.
Yes, that
Okay.
works.
So May 28th. So we've reset the prelim for May 28th at 10 o'clock. Please keep in contact with your attorney, Ms. Patrick. We'll see if witnesses need to be subpoenaed for that date. So the witnesses are to be subpoenaed for that date unless they hear differently from you. Anything else for the record in 26-01045, Ms. Maycomer?
No, Your Honor, thank you.
Ms. Patrick.
No, yeah, thank you.
All right, Ms. Timko, you should be all set. Thank you for your appearance today.
This is what. Yeah, it got sent to Flynn. He's got all these services in place. I was just gonna see if it was dismissed today. Sitting in, now they've got a plan in place for me, so I was like, let's just won't proceed. He's basically.
Sure.
Thank you, Judge.
All right, Ms. Maycomer, I have Ms. Donnelly on Schaefer and Wright.
Yes, if I can go call the hallway on Schaefer, Your Honor, one time.
All right.
But then I believe we're also ready on Ms. Wanji's plea for Mr. Gorney.
Mr. Gorney, that's right. And do you need Mr. Gorney brought up? Mr. Gorney's here.
Okay.
So we can go on that file. All right, so we're on the record in 26-01046. That's People, the State of Michigan versus Matthew Paul Gorney. Appearances for the record, Ms. Maycomer.
Good morning, Your Honor. Natalie Maycomer on behalf of the people.
Ms. Wanji.
Good morning, Your Honor. Melanie Wanji for Mr. Gorney, who's by my side at the council people.
And sir, you are Matthew Paul Gorney, is that correct?
Yes, sir.
All right, thank you. This is the time set for preliminary examination today. Ms. Maycomer, how are we proceeding?
Thank you, Your Honor. The people and defense have come to an agreement in this file for a plea that the defendant would plead guilty to an amended count 1 of stolen property, receiving and concealing less than 200. The PAC code on that is 750.5355. It is a 93-day misdemeanor and or $500 in fines.
All right.
There is a sentencing agreement to no further upfront jail at the time of sentencing.
All right, and is that a fair statement, Mr. Wanji? I'll reiterate for the record. It's amended count one of RNC. It'd be the RNC under $200, receiving concealing under $200. That's under 750.5355. It's a 93-day misdemeanor and or $500. And there is a Killebrew agreement between yourself and the people of the state of Michigan of no upfront jail.
Yes, Your Honor.
All right,
May I approach, Your Honor?
you may. You have an advice, you have a plea agreement and advice of rights. And Mr. Gorney, you signed the bottom of this. Is that correct? The advice of rights form?
Yes, sir.
All right. But you understand, Mr. Gorney, that there's a Killebrew agreement between Ms. Wanji and the people of the state of Michigan that you receive no upfront jail. If I was going to do anything differently from that, you'd have the ability to withdraw your plea. You understand that, sir?
Yes, sir.
All right. You've indicated an advice of rights. So I'm just going to go through your main rights in this. The highlight some of the rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to remain silent during the trial, not to have that silence used against you, and testify at trial if you choose to testify. Do you understand those rights, sir?
Yes, sir.
Okay. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading guilty to the receiving and concealing under $200. Is it still your wish today to plead guilty to the receiving and concealing under $200?
Yes, sir.
Okay. I'm going to have you raise your right hand as best you can. Do you solemnly swear or affirm? Tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes, sir.
I'm going to bring your attention, sir, back to April 17th, 2026 at the offense location of 3333 South Cedar Street in the city of Lansing, state of Michigan. Were you at the 3333 South Cedar Street address in the city of Lansing on April 17th, 2026?
Yes, sir.
And did you have property belonging that you did buy, receive, possess, conceal, or aid in that that was a musical instrument that was the property of others?
Yes, sir.
And you knew it was the property of others. You knew you shouldn't have it.
Yes, sir.
Okay. And you had reason to know that it was stolen, and you converted that property to the amount of over $200.
Yes, sir.
Anything towards a factual basis, Ms. Maycomer?
No, Your Honor.
Ms. Wanji?
No, Your Honor, thank you.
I find the factual basis to the amended count of receiving, concealing under $200 to be knowing, voluntarily, and accurately made. We'll refer to probation. Mostly refer to probation based on the Killebrew of no upfront jail, but they can make some determination on restitution also if there is any. So probation is one floor down all the way to your right, and you can go there. They'll either see you now or they'll set up an appointment to see you. I don't know who your probation agent or your probation officer will be, but we'll set sentencing for
June 18th at 9.
June 18th at 9 o'clock. All right, so we've set your sentencing date for June 18th at 9 o'clock. You can go down and contact probation for the pre-sentence interview. Anything else for the record in 2601046, Ms. Maycomer?
No, Your Honor.
Ms. Wanji?
No, Your Honor, thank you.
All right, Mr. Gorney, we'll see you on that June 18th date. Thank you for your appearance today.
Thank you, Your Honor.
Okay.
I'll meet you. I'll meet you. Yeah.
And if not, tell them that's present.
All right, did you want to call Schaefer?
Yeah, sure, I'm just gonna run the hall real quickly.
All right,
Your Honor, on right, it was set for a review hearing, right?
yeah, Wright was set just for a review.
I thought that would have been canceled because the competency report came in.
That I don't know.
Well, I mean, we had a competency hearing, we stipulated it, and we set it for a preliminary exam next week, I believe.
Yes,
Yeah,
we did set it for May 14th at 9:30, so I
I
so
thought
we-
the review hearing would have been canceled.
evidently it wasn't.
Okay.
But I think we can waive his appearance today, because I probably told him to be here May 14th.
Yeah,
Yeah,
yeah, you definitely did. And, but I mean, if you want to, we can, because I do have an update on him.
All right.
He apparently, he called me,
all right.
he called me on Monday, so.
So-
And then for Schaefer,
We're gonna dismiss.
okay, well then let's go, I'll waive his appearance and then go downstairs and give him a dismissal.
All right, so let's waive Schaefer's appearance and we can place Wright on the record, it appears.
Yes.
All right. All right, so we're on the record in docket 26-00581. That is People of the State of Michigan versus Isaiah Schaefer. Appearances for the record, Ms. Maycomer,
Morning, Your Honor, Natalie Maycomber on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Isaiah Schaefer, who isn't present, but he is in the courthouse. We're just waiving his appearance for these purposes.
All right. This is time set for preliminary examination in the matter. Ms. Maycomer, how are we proceeding?
Thank you, Your Honor. This time, the people do not have the necessary witnesses that are necessary obviously to continue. So we, at this point, leave it to the court's discretion.
And you are not, we are waiving Mr. Schaefer's appearance for these purposes. You're not requesting a bench warrant for his non-appearance, is that correct?
That's correct, Your
Okay.
Honor.
All right, there's a dismissal. The complaining victims or witnesses have failed to appear today. There are witnesses. They were subpoenaed. Is that correct, Ms. Maycomer?
They were, Your Honor, and they have been in contact with our office.
And has any of that contact been successful?
Successful as far as contact, yes. As far as hopes that they would appear, no.
Okay, okay. So the prosecuting party has been unsuccessful in getting him here after subpoena. And I will grant the motion to dismiss without prejudice. I'll have that printed out, and then Ms. Donnelly, we may draft you to hand that to me.
Is that on the prosecutor or the defense?
The defense.
Okay. Take them under current contract for those obligations, Your Honor.
So that would be the defense motion.
Yep. Oh, yeah, I totally did that motion.
Thank you, Ms. Donnelly. All right, so we're back on the record in 26-00581. The defendant's motion for dismissal is granted. And I do not have, I have a no contact order. I do not have a GPS. So Ms. Donnelly, you can provide a copy of the dismissal to your client and yourself for their own purposes. It takes about 4 hours to purge from the court system. So we'll issue a dismissal without prejudice. Ms. Donnelly, as you know, that means that people could reissue if they choose to, but for our purposes today, the case is dismissed.
Yes, Your Honor. I will be providing him the knowledge downstairs so that when he goes back to the Ingham County Jail, hopefully they've cleared it by then when he gets released.
All right. Anything else for the record in 26-00581, Ms. Maycomer?
No, Your Honor.
Ms. Donnelly?
No.
You should be all set. Thank you for your appearance today. And then let's go ahead and put Wright on the record. Huh? All right, so we're on the record in 26-00058 and 26-00068. That's people of the state of Michigan versus Tyler Wright. Appearances for the record, Ms. Maycomer.
Good morning, Your Honor. Natalie Maycomer on behalf of the people.
Ms. Donnelly.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Tyler Wright, who is not present.
All right, this is time set for a review hearing that we probably set previous to getting the competency report that was stipped to. We set this as a controlled date. We don't need it now because I've said to the defendant, he used to be here on May 14th at 9:30 for prelim on both files. That's a prelim set as May 14th at 9:30 on 26-00058 and May 14th at 9:30 on 26-00068. So at this time, we would just leave that prelim on and cancel the control date that's been set. Is that a fair statement, Ms. McComber? And do you want to add anything to the record?
That is fair, Your Honor, and nothing to add. Thank you.
All right, Ms. Donnelly, anything you want to add to the record?
Yes, Your Honor. Yes, what you've stated so far is correct. I just wanted to inform the court, because I have, you on the record, that Mr. Wright contacted me on Monday. He was at that time at Havenwick Hospital. Mr. Wright has mental illnesses, and it's my experience that I found that he's been going in and out of hospitals, it seems. So he reported to me that he was at Havenwick. He didn't know if he had been there for a week or two, but his understanding was that it was a short-term facility and that they were looking for more something long-term. So at this time, I'm not sure if he's going to be not hospitalized at the time of the preliminary exam next week. I was going to keep obviously the court and the prosecutor updated, partly why I'm doing it now, and I'm keeping you guys updated. So because I at this time I think it might be premature. He might be able to still appear next week. So I didn't know if we said it now. So I'm just telling the court, but I expect that to see what happens next week, and I'll keep the prosecutor's office informed about witnesses and stuff.
All right, if you could keep the prosecutor's offices concerning witnesses concerned, whether they need to subpoena or not. Mr. Wright is in a psychiatric hospital at this time, and then may or may not be released. So we're not sure. So I'll leave it to negotiations to continue between yourself and the people.
I will obviously, I have contact information for his mother.
Okay.
So my hope is that I can get more info from his mother, whether or not I can get it from him before next week.
Right. All right. So we've set it for May 14th at 9:30. It may or may not go. And if he is able to attend, it may be via Zoom.
Okay.
Yeah, just in case.
Just to have his face appear.
Yeah, because we won't have a writ done, but with the understanding that that's only the facilities.
If he's still in the hospital.
Yeah, if he's still in the hospital.
And the facility will allow it, obviously.
Right.
Yeah, try.
Anything else for the record in 26-00068 or 26-00058? I've just left it on for the prelim for May 14th at 9:30. Anything else, Ms. McComber?
No, Your Honor.
Ms. Donnelly?
No, thank you.
All right, you should be all set, ma'am. Thank you for your appearance today. Right. No, because we're not sure, and that would be too soon anyway.
Yeah.
All right, we have Montrell Taylor. All right, that's Ms. Schroeder's.
Yes, Ms. Schroeder was in Judge Ward's, and then she was
All right,
going to talk.
so we know where Ms. Schroeder is. She's just not here. And so Mr. Lee on Layton.
Yes, I've talked to Mr. Lee. He's intending to run that exam.
Okay.
Mr. Ned is on Robinson. Down to talk to him again.
All right. So we may need Robinson brought up. We may not, depending if, and all right.
We will need Layton at some point, just not yet. I'm not sure Mr. Lee is.
All right.
We're gonna leave with the idea, Taylor, with the idea of if he pleads dismiss the felony firearm circuit.
If she's ready, whenever she.
Oh, I didn't even see you. Oh, my goodness.
All right.
Oh, it's okay.
So do you want, let's bring up Leighton then. And we'll go on Ms. Schroeder's.
Or with my witnesses on
Okay.
the judge,
Okay.
because I think I have way too many here.
She want me to waive it Leighton or,
No, you can,
oh, okay.
no, we can do Taylor right now, though.
Yes.
All right, let's do Taylor and you can go get
Leighton.
Leighton.
Yep.
And then we'll let Ms. Maycomer talk to her witnesses.
Okay. Carolyn, you have a pen?
I have a pen.
Oh, you have a pen? Is it pink though? Oh,
It's not-
okay.
I have a pink one.
I've met you.
I know.
All right, so we are on the record in docket 26-00652. That is People of the State of Michigan versus Montrell Taylor. Appearances for the record, Ms. Maycomer.
Good morning, Your Honor. Natalie Macomber on behalf of the people.
Ms. Schroeder.
Thank you, Your Honor. Our Assistant Public Defender, Aaron Schroeder, on behalf of Mr. Taylor, who is present, stands to my right.
And sir, you are Montrell Taylor, is that correct? Yes, sir. All right, thank you. This is the time set for preliminary examination today. Ms. Maycomer, how are we proceeding?
At this time, people and defense will be waiving the right to hold a preliminary examination in this matter. We ask that the case bend over on the charges in the complaint. There is an offer to place on the record, and that is that the defendant at the circuit court level will enter a guilty plea as to counts 1 and 2. Count 3 would be dismissed upon the successful plea and sentence.
Is that your understanding, Ms. Schroeder?
Yes, Your Honor, and as always, I would continue negotiation, but that would be where we would certainly be starting at once we get to circuit. Thank
All
you.
right. All right, and may I inquire of Mr. Taylor of his waiver of the preliminary examination?
You may, Your Honor.
Mr. Taylor, you understand you have a right to a preliminary examination within 20, you have a right to the preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented by Attorney Aaron Schroeder today, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case to continue in circuit court. The offer has been placed on the record and negotiations are going to continue.
Yes,
Is it your wish today to waive your right to a preliminary examination today?
Yes, sir.
Do the people also waive their right to a preliminary examination, Ms. Maycomer?
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. I'll provide the, Ms. Schroeder, I may draft you to, for the bind over documentation.
Very good, Your Honor.
Thank you.
Yep, and that was that. All
Mhm.
right, so this is the same thing that the judge just kind of knows. Right to the return, may request court appointment, if you're financially needed, you have the right to preliminary exam, show crimes committed, probable cause we need to exist to charge you voluntarily waive my right to preliminary exam. Understand it will be sent over to the circuit court on the charges. If you're cool with that, sign right there. And I will sign as well. And there you go. I'll give you back the pen as well. There you go. Thanks. All right. My approach, Your Honor.
You may. Thank you, Mrs. Schroeder.
Yep, you're welcome.
All right. I'm in possession of the bind over documentation on 26-00652. I'm going to indicate it's signed by all the parties. I'm going to waive the examination date on today's date, which is May 8th, 2026. The bond has been set and it's PR bonded. Anything else to come to the court's attention before the court signs the bind over documentation, Ms. Maycomer?
No, Your Honor.
Ms. Schroeder?
No, Your Honor.
All right. I'm going to sign. Your time in district court is done. So after circuit court, will you get your next date to appear from your attorney, Ms. Schroeder? All right, sir?
Yes, sir.
All right. I'm going to sign the bind over documentation. You should be all set. Thank you for your appearance.
All right, thank you, Your Honor. Thanks, Natalie.
Thank you, Ms. Schroeder.
Yes. I don't, no, you don't need to wait for any paperwork. They're just gonna send over the stuff to the circuit
Right.
court. Okay. All right.
I'm going to the witness room and talk.
Yeah, you can talk to your witnesses. Just let me know when you're ready and then we'll because we're bringing up Layton and we're waiting to hear from Mr. Annette on Robinson.
Yes.
Okay,
All right.
thanks.
Maybe seated.
Go to the bathroom. What? I don't. Are we
What you got going on?
Waiver. What do you think? Die. Cuban sandwich. Sounds good. Oh, yeah. Good. That's right. It's gonna be a good day.
When I leave, so. Now, do you know if his new charge, is that gonna affect this charge?
No. Each of those charges. There's no shade. Just up trouble. Yeah. Because nothing else. Especially my judge.
Oh, yeah, she will not play. Everybody, you go to jail, you go to jail, everybody.
Everybody go to jail. She ain't playing no game. Right. Whoa. I try to coach him. I'm not telling you for my benefit. I don't really care. I'm going home at 5. I don't get no commission. So I'm trying to help you. With Denzel saying training day, you want to go to jail, you want to go home. That's right. That's right. There it is. I'm telling you. I'll be trying to put them up.
You only gave the best advice you can.
Man, I'm trying to tell you.
The rest is in their hands.
I gotta tell them about the elevator. That's a hot mic.
Oh, yeah. Oh, yeah.
That is not a confession with a priest. Oh, that's going straight to prosecution.
What's going on, man?
Man, we're gonna go get a Cuban a little bit.
Man, y'all a lifesaver, because Robinson always give him headaches, man. Every time I deal with him, man.
Oh,
Remember last time?
Yeah, I never forget. He gets pissed off because he's like, he don't understand certain counties. They don't
They do different roles.
Yeah, I'm like, bro.
But not only that, the flashlight issue.
Oh,
that was
hey,
them?
bro.
That was them?
They swore up and down, like me and Ether's got this conspiracy with the flashlight. So I'm like, look, he come to find out what officers.
I know. They're trying to put the blame on you guys.
Immediately. Well, he didn't have it. Look, I got eyes on him. Everybody had eyes on him. Nothing was taken off the table.
So he put it in his pocket or something? Where do you have it?
I guess when the officer, I guess when they were arraigned him or something, because immediately one officer was like, what kind of flashlight? All of a sudden silence. I'm like, first, nobody would even have that type of flashlight up here.
Right,
it was
right.
one of them technical flashlights. Like, that's not enough. So they found out one officer. They swore him down. Me and Esther, like, we interrogation room, like, bro,
Yeah.
run the cameras.
She email tried to trick me. She's like, oh, Mr. Ether, we found your flashlight.
Oh,
Yeah, come on, man.
You don't want to come get it.
Like,
I'm
we
like, what
invested
flashlight?
first 48 or something.
I don't bring
like-
flashlights to fucking court.
No.
That's funny.
And then I was like, look, okay, cameras don't lie. Run the camera.
Right.
Because where he was sitting, it's a camera sitting
Yeah,
right there
yeah.
on 2 different angles. Let's run the camera. My fault.
They find the video where he took out some officer's pocket?
No,
But yeah,
but he knew it because he said, wait a minute. And it dawned on him that it was another officer's.
Yeah, he wanted to try to not say it, yeah.
Now he was the only one, that's my guy, I can't remember his name. He's the only one who was like, nah. I said, bro, come on, man.
Yeah.
I guess this, at least ask me first. Don't accuse me as if like we hide some conspiracy or something like that, flashlight.
Right.
I said, because my thing is, even if it had to happen, it's not intentional. But
that's true.
Check all your investigations first.
Right.
Before you assume we didn't did it up here, you know. Hey, the funniest one I ever had, though, I kid you not, this is the funniest thing. He was a guy downstairs. I can't remember his name, he used to always come over here. But when I called out there, the guys was pissed. He's like, hey, he's back there causing disturbance. I said, what do you do? He had stole somebody's sandwich. Hold on. Out of all the charges y'all got downstairs, you worry about somebody stealing a sandwich. Please tell me I work a sandwich. So he's laughing about it. You know there.
Right.
I said, man, what's going on? He said, man, he trying to say I stole this sandwich. I said, did you? He said, no, he didn't want the sandwich. So I took it. There it is, no crime done.
Right. Yeah. Right.
You'd have thought he'd have stole every sandwich in the county. Oh man, they was. That's what they was. His. I said, people take sandwiches all the time.
All the time.
You should be glad people eat the bologna sandwich. You should be handing them out to everybody.
Ain't nobody want them.
Man, they talking like it was a doggone Whopper from They was, when I tell you, it was pissed off. I said, he's hungry. I mean, if it's make, and the other part is, y'all got a whole basket full of sandwiches people ain't make.
Right, nobody wants that garbage.
Like I picked the wrong battles on the wrong days to be mad. Hey, one guy we had came from Jackson County. He got knocked out in Jackson County. Bro, that's like one of the ambulance.
Yeah, because I mean, if you're either working at the jail out there or working in the prison out
Bro,
there.
when I was, you know, I'm from there. So I worked there about 7 years in Circuit Court District. Like Detroit, scared to death. Like if I ever got somebody from Detroit, like man, ain't gonna see one of them judges. Because here's Jackson's thing. Problem with Jackson is we're in the middle. Go this way, you got Detroit. This way, you got Chicago, Lansing.
It's the hub.
Everybody comes.
That's the hub.
You know what I'm saying?
That's the hub.
It's more people. The last time I went down there, I don't go down there much because Jackson's like Chirac. Last time I went, like 5 boys came in, they had all Chicago stuff on. I don't even recognize people down no more because like Chicago took over.
Yeah.
But that's why the gangs out of control,
Yeah.
man.
Yeah.
Like last time I went to a game down there, I didn't know half the people down there, but they moved in. At one point, the housing was cheap, but you know that's changed everywhere. Like I said, the highway, like to the life of me, there's a hotel nobody ever shut it down. It exits here to get off. It's hotels is red. Every crime known
It's
man.
a hub. It's a hub. That's
Every
the trades,
crime.
the deals.
Bro, every crime known man.
The Johnnies.
Oh yeah, all day. It's like 28th Street, Grand Rapids.
All right, right.
Hey, the funny thing is, I was like, man, I was probably like 16, 17. I got family in Grand Rapids, so we was going down 28th Street. And I was like, some uncles, man. Let me keep walking around, stopping at the stop sign. Son, you don't want to.
No, I know.
Stay far away.
Yeah, stay far away. Just like Kalamazoo Street here. But I don't really, I don't see it. Maybe it's not summertime yet.
Oh, it's still cold.
Yeah.
Man. You gotta wait.
It's those apartments right there. It's those apartments on both sides.
Oh yeah, you gotta wait till you go outside. This is crazy. So this dude in Jackson literally had a SpongeBob the Cutlets when they was doing that. See, that's back in my generation.
I've seen one here in Lansing.
They had a
And
SpongeBob.
you've seen the Teenage Mutant Ninja Turtle one,
Yes,
right?
they had a Skittles one. I'm like, oh, at least get an endorsement.
Yeah, right.
You know what I'm saying? You get free
You know,
press.
the old plastic cutlass,
They used to put,
big old rims.
yeah, they had,
It's all spun out of, you know, I think I probably, if I've seen his TikTok, I think I've
it's been,
seen on
man,
Lansing.
that was back.
I knew the guy, the one that had the Teenage Mutant Ninja Turtles here
Yeah.
in Lansing. I
One
was
had,
gonna buy it at one point, he wanted $5 grand for about 8 years ago.
and I'll tell you, the coldest one I've ever seen was the Joker.
Is it around here?
No, it was in Jackson, it's like Joker.
I know, right? That's funny as hell.
Then they used to have, when the Chargers first came out, everybody was getting suicide doors.
Yeah.
And
I still get to this day, I love it.
yeah, I like the old.
I'd still, if I had bought a classic, I'd still put it on there.
I like the big lines.
Yeah.
The Challengers, it's one guy, believe it or not, he's got one that's all purple. But he's got a Hellcat, he got the logo side, man. It's stupid. Like, purple is, it's sick, man. Like when I used to live in Indianapolis, I used to go to the car show, street car show. That year, Shaq brought one of his cars.
Shaq?
Yeah, he had brought some of his cars. This is back when Latrell Speedboy Auto was out. He brought one. He had the spinners and all that.
What is it?
Latrell Speedwell. He used to play for the Knicks. He used to have the rims called spinners.
Yeah. Oh yeah.
So he brought his couple people I take cars, man. Like the one in Atlanta I'll never go to because Rick Ross, they rip people off.
Man.
He
The Rick Ross car show?
And he ripped
I've been wanting to go for the last 3 years now.
Bro, he ripping people off.
I was gonna go this last one, but I didn't.
I'll put it like this. Unless you
a fan of Rick Ross?
I'll tell you why I'm not off record, but I'll say this. I like his early music.
Me too. Music lately is
trash.
like Snakes in Miami. I don't like that. I just saw. You see me? I was just out there about a month or two ago.
Yeah.
That's
His new stuff is trash.
It's not the best. His old stuff is amazing.
No.
I used to love this. It's be my ringtone back in the day.
When he first came out, it's funny because it was him,
With Fat Joe,
Future, all of them kind of came out at the same time. His car shows is trash because unless you live there, see the problem is
you gotta get your car there.
Well, the other problem is this too. They were turning people away that had legitimate tickets because he didn't have it organized. Man, you can't have it.
Yeah, maybe it's better. It gotta be better now.
Well,
it's his fourth or fifth one now.
Well, the other problem is he get complaints from the
From the neighbors. I know. Yeah, they don't want him doing it. I already know.
Hey, yeah, let's go.
I know. The promised land.
I used to work.
The biggest pool in the United States.
I used to work over by where his house was. And man,
is it Lafayette, Georgia, or whatever?
It's crazy.
Yeah, I've been wanting to go for years, man. I think I'm gonna go this year. I think it's in June.
Yes, in June.
I think I'm gonna go this year.
I mean, think about it, man. See Slims at, I just know it to the grocery store.
Yeah, see that, yeah.
But it's a lot of money you made.
Yeah. Oh, I know.
If you do like construction.
Houses being built every day.
Oh, man, I try to get my brother, my nigga around here. This dude, they making 6 figures in construction. Like when my sister lived in there, they built a whole new, like they built a whole new complex. 300,000 homes.
I know.
What I hate was I was out there before they almost. And just once the stadium was
Property value. It's that land alone. Yeah, I know.
like if I could have bought property, I'm sorry, if I could have bought property by Little Caesars Arena, when it was getting built,
You'd be a millionaire. Just like sitting on it. I already know.
I just want to buy a parking lot downtown.
George was almost a millionaire. He was like,
Oh, you're about the ticket at my store, the $1 million ticket Lansing. That was at my store.
Oh,
I'm mad. He's crazy. There's 6 tickets left. I bought 3 the day before. He was there, and he's like, "Man, those tickets don't run." I hate those tickets. I spent hundreds at the gas, and I won nothing. So you know, let me get to the last day. I was gonna buy him that night, 2 hours later, because I didn't want to spend $300. I already, he bought them. He's like, "Man, he won't let me cash it. He wouldn't let me. He wouldn't tell me what it was." So I said, "Right, call me when you get home." He called me back. It's $1 million winner. I didn't really, I believe him, but I didn't believe him, so I saw the news. $1 million, after taxes, he came back, he only got 490 after taxes. Yeah, 490 after everything.
Man, that's nothing worse. Like, it's over half.
490, unless he was lying, unless he's been, you know, he told me he took 300 off the top or something.
I mean, don't get me wrong, I ain't complaining about
Right.
400, you know what I mean? But.
You're set.
Um,
Man, you put down, you open up 20 businesses,
Man.
pull a deposit down, and pay for yourself.
I'm going down, I'm
That's
going.
what I said.
Look, we had a little thing in our office. What do we need in Lansing? Waffle House. In and out,
Cash money.
White Castle, Waffle House, 24/7.
One thing about Waffle House, I understand. You got to spend at least,
For the franchise fee
well, your security.
and security.
Just-
Yeah,
Security.
24 hours.
You guys have a lot of security,
Yeah.
all that.
Yeah.
Like my dad, restaurant guys, his thing was this, you get your food, get out.
Yeah.
Load it in the
Yeah.
parking lot.
Kind of like Detroit, you know, you got the boat, you get your food and leave.
Well, it's Atlanta, see, Atlanta is the same, I don't understand that. Why they don't let this happen? Atlanta, they let the police, like my brother-in-law was part-time, like after.
We let the police work time at the shops.
Like the restaurants.
They do that in Meridian Township. I know a security officer that works part-time at Apple.
Oh,
They let them do it. I think there's something against it, but they should let them do it.
Man, we went to Applebee's. She was like, oh, this is the guy. So about 10 o'clock.
Yeah, so, yeah.
She's before the DJ, she had 2 sheriff guys. They had to do it. 0 issues.
Yeah, yeah.
Want to fight with
Security is
this
one
guy,
thing, the cop is
cop,
another.
whole different.
It's a whole different ballpark. You're going to jail now.
Thank you.
And then we're gonna kick you out. You're going to jail.
Yes, and the jury stores in Atlanta, straight police officers. You know, it's stash and grab. They stash and grab.
And I'm just getting all the videos on Facebook. It's horrible.
Cause my brother-in-law,
They
I
move,
mean,
man, they do a broad daylight.
oh yeah,
And what else?
they did it, no, they did it in Jackson, and Meadowlark.
Hey, John,
Did you say, hey, John?
I did. We got a hold of him. He's working right now. He can be here in an hour. This is what he's saying. So we have to. Or whatever it is.
I don't want
He's
you.
ever doing, and then I'm down.
Okay,
Where,
so we'd be
Jackson?
running this at like 1 o'clock or whatever.
Well,
That's
yeah,
bold,
that's-
my bro, just. It's bold.
we have to talk to the judge because we have.
You gotta start going. Shut on someone's home side. That is not okay. Like houses do, like if they buy it to be at quarter certain times, they can't rearrange everything for me to do. So. Yeah, credit. You can ask your owner that stuff.
I know they're gonna. Slow down, because it's not gonna get that. But. They, if there's this afternoon, I understand still the concerns with that, but that's just what I'm gonna ask.
Sure. Okay, fair enough. That's, I would do the same if I was in your shoes, so. Fair
Ms. Robinson,
We'll wait.
the way.
Okay.
enough.
I'm gonna let her.
Let her know. He's.
Just because we can go. We should have.
I think it's.
I'm sorry.
Should let her know. Natalie, do you think just because it's too many times she's brought this forward? I think we should get it out of the way now.
Yeah, well, I'll have to adjourn.
She gotta go get her.
I don't know if the baby, so if they're not,
Apparently, I didn't know. I'm just helping out.
just
Yeah.
call me or whatever, let me know how it goes.
Like,
Alright, I'll let you know. I've
Big,
never been to
so,
9 o'clock,
like,
so
flashlights.
just let me, call
you.
me later, and let me know.
He's okay with these. He's been fine.
Oh, I guess he did.
I love you.
We just.
Oh.
We just wanted to go.
He got accused of giving
I'm
a
glad she didn't
flashlight.
bring my food.
Oh, yeah, we got cruiser flash.
Yeah. I would
Imagine that.
down.
Imagine it. They interrogated us like we was criminals.
Shut up.
Seriously.
Seriously?
Yes.
They emailed me when we get my
Yes.
flashlight back. That's all it is.
I get on there like,
I have my child.
yeah, flashlight is flash.
I don't have my friend. I'm not.
Yeah, don't do me.
We gotta do me. Give me the phone. It was
No,
one-
because I had my son, so I had to take for a whole baby.
So make sure we come protect. So make sure you got.
You know, when
flash.
she, does she have anybody out there? Yeah, he's got a new caretaker, and he lives somewhere.
Even if we did, that's not. Actually, stuff happens here, the situation like we brought it. No, I mean, we want to do it all.
Yeah, you just can't sometimes do everything. you absolutely want to.
Still talking.
Yes.
Yeah.
No, we're ready.
Oh, you ready?
Yeah,
Oh. I guess we're ready to rock.
Are we?
Oh, you say hungry? Yeah, yep, that's the magic word today.
Super safe.
Yeah.
Shoot. I'm starving. Candy all morning.
Then you get some prosecutor says, we'll just hang out for another hour. We'll run this hearing in a minute.
You would think this is my lunch today. This is cough drops.
Trust me, if this were my case from before today, people would be here. They would knew it. What time was this? They would have been here then. It would be.
We'll have some candy. They done ate all of it. We got candy here. They took all the candy.
Okay.
You want coffee?
That's right.
Actually,
But everyone has to do like people that everything right, but if I can't make it one day, or I get hit by a bus, you go in my house to pick up my car. Right, like, there's no- I already have to use it now, and everything is
They don't find it so. I'm trying to do more.
All rise.
You can be seated. This is Mr. Layton.
It is your.
All right, so we're on the record in 26-00870. That's people of the state of Michigan versus Zachary Layton. Appearances for the record, Ms. Maycomb.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
Mr. Lee.
Good afternoon, Your Honor. Assistant Public Defender John Lee on behalf of Zachary Layton, who is in the courtroom and standing to my right.
And sir, you are Zachary Layton, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination today. Ms. Maycomber, how are we proceeding?
Thank you, Your Honor. Your Honor, at this time, the people are going to ask the court if it is possible to hold this examination in approximately an hour or sometime this afternoon. I know that we have a busy afternoon.
Well, because you're here.
Because I'm here.
Because you.
I have taken up your afternoon.
Yeah, so, but that, if we're gonna address the preliminary examination, we can do it this afternoon.
And just so the court's aware, the reason being the necessary witness, which my understanding is this was dismissed previously because that witness did not appear. The police officer who was in Lansing Police Department officer is now with the East Lansing Department.
All right.
Our office subpoenaed the officer's Lansing subpoena information. So he never got his subpoena. We were able to get in contact with him. He is working right now in East Lansing, but he can be here in about an hour. So we can proceed, just not at the scheduled time.
All right, Mr. Lee, did you want to make a record?
Yes, Your Honor. We would ask the court to consider a dismissal in this case. This is the second time that we have appeared for a preliminary exam. It is the second time that this witness has failed to appear. So we would ask the court to consider that and consider a dismissal.
All right, thank you. I don't have a problem moving this, waiting till 1:30 because we have at least 4 or 5 other files and we've already done a prelim on those. And then we have another sentencing. So we'll adjourn or recess to 1:30. And then we'll see if we'll see where we go at that point. So Mr. Layton's preliminary examination, he will get his prelim. He will get it within the time frame, but we'll start it in the 1:30 arena. Anything else for the record in 26-00870, Ms. Maycomber?
No, Your Honor.
Mr. Lee?
No, thank you, Your Honor.
All right, Mr. Layton, we'll see you about 1:30 this afternoon. And then did we hear on Mr. Robinson, Mr. Aned?
He can come up.
All right.
It's gonna be a waiver.
All right, let's bring him up.
Okay. What's that? Oh,
Jason Robinson.
thank you.
A flashlight.
Yeah, thank you.
Well, they switch out, I'm gonna go let them know.
All right.
Officer will be notified at 1:30.
All right.
Lunch. Yeah, I think we're gonna go.
Yeah, Robinson's gonna be a waiver.
Oh, look at that.
We'll address Layton at 1:30.
Or we go right now, shit, we were- I go
We
there.
already have Jackson's at 1:30. And Bedell
We're doing
is
something, try to-
Donovan's.
Would you bring a bagel? Cream cheese?
Higgy. Is it Higgy?
Oh.
Hagee.
Hagee?
Hagee,
It
yeah,
just popped into my head.
Hagee.
That's
Are-
one area I would love to go, like Norway, Sweden, you know, all those.
We
Oh,
went,
Not now, wait a minute. Let me see. Otherwise.
wasn't this year, we went last year.
Did you get bit?
No, I've got
Yeah.
skin, so I have to be careful with what I eat.
Well, that's why-
Like in regard
That's
to
what
dairy.
Oh,
I'm not good at it. I used to be really good at it, I'm not good at it anymore. And,
Okay, just making sure, because I have not been bit since.
yeah, no, I get a little dermatitis from dairy and I have to be really careful and I haven't.
Okay.
And
All right.
we were on vacation, blah, blah, blah,
Oh,
but
for sure.
But as I get older, it gets worse.
So annoying.
We went to the areas of that, but we didn't go to Greenland or Iceland. And that's supposed to be really pretty
Yeah.
good. Yeah.
Yeah.
So we went to like the Dolomites, Sweden, Switzerland, all that. And that was cool. And they were all getting ready for the Olympics. That was really neat to see. And it's just beautiful.
Yeah, that's on my.
But I would
could
like to
travel, I
see,
would love to go
yeah.
there.
I'd like to see, I think, the UK was on my list and Ireland's on my list. I'd like to see Ireland just like spend a week just going to places in Ireland. I don't want to make it a part of something. I want to make it its own.
I'd be like.
Ireland and Wales would be part of that.
Sometimes I'll do like I do for
Oh.
me. Like,
So, because Ireland's supposed to be beautiful.
Yeah, that's what I've heard. I agree.
And his,
How are you, Joel?
Doing well, Judge. How are you?
Pretty good.
Good.
and there's money in his car.
Okay.
I-
You want this up after all?
No, this
You don't?
is- no, it's what it is.
Okay.
Um,
They were so hot in the news that the lakes are.
Ah, that's
had
funny.
So much rain and
So
snow
those
and
ones we
stuff.
have, they're all here.
You know,
Got it.
these big
They're in
storms
there,
that
and
up
then-
north is that the lakes are rising.
Oh, I'm gonna forward
And
you
it
the
was
last.
so
I got it.
interesting.
I got it.
I don't know, 5 years
Wait,
ago.
should I talk to her?
We would
Oh.
So
go
he said.
at least once a summer to
Yes.
South Haven, just to go to the beach. And we went it for a couple of years in a row. And so one year we went and the amount of beach was.
Well, we saw this
like,
morning.
It was so
Yeah.
big.
Because the water was down. I
It was
think.
down, and then the next year it
All
was
right,
so
cool. Thank you.
small.
I
And we're
appreciate
like,
it. So I'm gonna-
it
once he
just
comes
is like
back up,
weird.
he'll
It was
be
like,
for sure.
didn't have very much far, very far to walk from the car to the water because it
This
had.
year it's really up.
That's what I've
Yeah.
heard.
Yeah,
Just let me take care of it,
we
okay?
had
Okay.
some
Good.
damage on Grand Lake.
Oh, did
Yeah,
you?
yep, we had, one of the boats were damaged and we had water in the boathouse. But nothing compared to neighbors of ours who actually got flooded. So that
Oh.
we were like, because we're up a bit.
Okay.
But that water rose pretty good. Yeah, they got a lot of water.
Yeah, yeah. Well, good that you didn't have worse
Yeah.
damage, I guess. What kind of boats do you have?
We have the pontoon was fine.
Oh.
There's a working boat that we fish out of. And that was kind of beaten up a bit. And that was my father-in-law, so I think the girls took it kind of hard, because that's the boat they fished in.
Yeah.
So, and that, she's like, do you think we can fix it? I'm like, yeah, we can fix it, but you may want to get a new boat. Because that looked really rough, you know.
Well, there was, I don't know, this past year had windy. Just,
Yeah,
it's been crazy.
I'll try to get you a raise.
Eh, I'm on a bargaining team and I just had to, apparently, if you sign up to get like an HSA, you have to actually open an HSA account. I just assumed the county did that.
It was the worst experience of my career is being on the bargaining team.
Oh,
It
so
was, it was a terrible experience because you're wrangling 30 lawyers that may or and lawyers can be vociferous or not, depending. We had a lot of younger lawyers, so they wanted raises.
yeah.
We had a lot of older lawyers that wanted benefits, and we were caught right in the middle. And they were fighting each other. And you're like, I didn't sign up for more fighting, you know.
I demanded to be on our bargaining team because I wanted a clothing allowance. And I refused to budge on that. So we got one. And then these guys,
Thank you, Natalie.
they said, well, the prosecutors got it. So they, you know how much work I put into that?
Thank you for all that
So
work.
angry.
Right,
But-
right. That's what you do. You go to see whatever the bargaining committees have. They're like, well, they have it. How come we don't have it?
Because I fought and I screamed and I literally said, I'm not leaving here. You're not gonna give us that.
I remember we were having dinner and we had Mark and Sue Adams and they shared time. And Mark Adams said, we should just strike. And I remember being in the conversation where like nobody would care if the people struck. Okay. We could strike and we could go with our signs in front of the buildings and nobody would care. I think we'd make about a third of the population really happy. Okay. that we're not coming to work. And I said, so Mark, that's not an option. Okay. We don't have that as an option as a collective bargaining unit. It was just ridiculous, but it was kind of, we just had a age demographic that we ended up, that ended up being a problem. If you were near retirement, you wanted more, a bigger qualifier, more benefits. And if you were new, you wanted more pay.
Yeah.
We were kind of stuck in the middle. Right, is this Mr. Robinson?
Yes, Judge.
All right. All right, so we're on the record in 26-00792. That's people of the state of Michigan versus Jason Robinson. Appearances for the record, Ms. Makeover.
Good morning, Your Honor. Natalie Makeover on behalf of the people.
Mr. Annette.
George and the deputy on behalf of my client saying to my right.
And sir, you are Jason Robinson, is that correct? Is that a yes, sir? You're gonna have to say yes.
No.
So that's yes. You are Jason Robinson.
Yes.
All right, thank you. This is the time set for a preliminary examination in the matter. Ms. Makeover, how are we proceeding?
Thank you, Your Honor. It's my understanding that both the people and the defense will be unconditionally waiving the right to hold a preliminary examination in the matter. We ask that this case be bound over on the charges in the complaint.
And is that a fair statement, Mr. Annette?
After discussion with my client, Your Honor, yes, necessary witness has appeared, and because of that, my client wants to unconditionally waive his rights, and we want to address bond.
All right. May I first address your client concerning his waiver of the preliminary examination?
Yes, Your Honor.
All right, Mr. Robinson, you understand you have a right to preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Georges Annette, and you would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is going to be your wish to waive your right to preliminary examination, have this case continue to circuit court, where that'll be the trial court. Is it your wish today to waive your right to a preliminary examination today?
Yes, sir.
Okay. Ms. Makeover, do the people also waive their right to a preliminary examination?
Yes, Your Honor.
I find the waiver of the preliminary examination be knowing, voluntarily, and accurately made. And I'll provide the bind over documentation for signature purposes. Thank you, Mr. Wormsley.
Oh, Your Honor, do we have a, yes, no date?
Yeah, I don't think we have an arraignment date in circuit court.
Oh, yes.
Reason why I asked that before I sign this, I have an outdated ink in King County and on the 5th.
Yeah, he's gonna make before I sign it, we're gonna address bond.
Okay.
But
Yeah, I just don't want to sign
that's only for the preliminary examination waiver. I don't want to get the two confused.
Okay.
Okay.
And this is what again?
This is just a preliminary examination to waive your preliminary examination to have
Oh,
it
okay.
continue in circuit
Yes, sir.
court.
Okay.
All right, I will sign the bind over documentation. The examination has been waived on today's date, which will be May 8th, 2026. And before I sign the bind over documentation, Mr. Ned, would you like to be heard on bond?
Thank you, Your Honor. It's my understanding that my client has been in custody, not just on this case, but other matters for about close to 10 months now. His bond, to my understanding, is 10,000, 10%. We're asking the court, if they would be inclined to lower just to 3,000, 10%, not a PR bond, just to see if hopefully when my client is out of custody in Kent County on June 5th, he'll hopefully post bond and be released pending this matter. He's been, I understand this is a felony, Your Honor, but he's been in custody for 10 months now on $1,000 bond. If it gets lowered to 300, his hope is he can maybe gather enough money to hopefully get out with $300. He's gonna be living in the Grand Rapids area.
Yeah.
He has no reason to come back here. He's not gonna be staying here in any shape, way, or form. So it's my understanding the complainant lives here. He has no reason to come down here for any, unless it's court related. He will not be coming to the city of Lansing unless told otherwise by the court.
All right, thank you. Ms. McComber, do you have any comment from the people?
Yeah, sure, thank you. Mr. Robinson is currently facing not only the assault, GBH, and the domestic violence second offense, but he is a habitual offender fourth mandatory minimum 25-year notice on this file. This is an assaultive crime on a intimate partner and an issue in which, quite honestly, Your Honor, the victim is terrified that this defendant will retaliate against her for appearing in court today, and that there will be further harm done to her. We've asked the court leave bond as is.
All right. Based on count 1 and count 2 of the assault GBH with the 10-year and the domestic violence, the victim did appear today, hence the waiver, which is a good tactical decision. And there's a prior history. I'm going to deny the modification of bond. And we'll keep it at 10,000, 10%. I'm going to sign anything else to come to the court's attention concerning the bind over, Ms. McComber.
No, Your Honor.
All right.
Nothing further, Your Honor.
All right. I will sign the bind over documentation. You'll get your next date to appear from your attorney, Mr. Ned. You should be all set, Mr. Robinson.
Morning, Your Honor.
Good morning, Mr. Feigelson. How are you?
Well, how about yourself?
Pretty good, pretty good. So we are gonna do Mr. Layton at 1:30 with the Jacksons. And are you here on the Bedell sentencing? Okay. We don't do a lot on those, but that's.
Spoiler, I'm probably gonna say leave it here.
Yeah, all right. I assumed. All right, so I'll see you after lunch.
Thank you, Judge.
All right, thank you.
All right.
I'll probably see you back.
You want to go? What were you saying?
You made it easy.
Yeah. Mandatory minimum. You don't, you get it at circuit court arraignment now. Don't ask me.
We used to get it on the. Yeah, that's how we get the date.
Not anymore.
Not anymore.
It's a different process now for some reason.
Yeah.
I don't know what. Mandatory minimum 25 years. Sorry.
Glad you let me know that.
No.
So now,
To be fair, I thought you guys got that with the discovery.
no, we didn't get anywhere.
It doesn't get filed until circuit.
I just need to know.
You should probably email, now that you're a big boss man.
Yeah.
Congratulations, buddy. Email like Nikki and be like, we need this.
Yeah.
Because.
Yeah, I will. I'll call her Flores and then
Yeah.
one of the.
Yeah.
I just need to know when I reassign it, what little attorney to give it to.
Yeah. Sorry.
Yeah, it's all right. Thank you.
Yep.
My phone's back there.
So, you're all set. We don't have a new date. Yeah, yeah, there's. It's the original statute. We don't have a new date yet. When we get a new date, we'll get this report. There'll be a packet or contact you, whichever guy decides you.
So why wasn't there another date? Because that just gives them time to bond out, because he's walking out the door saying, I'm still gonna bond out, I'm still gonna bond out.
I know he's saying that. They were very. There's not another date yet because they're just not released yet. So what happens is once a case gets found in our district court, it happened today. It takes a couple weeks to get to the circuit court. Once it gets to the circuit court, it needs to be assigned to a judge, and then that judge gets the date. So until it gets to that judge, remember dates. He will still be held on his current bond, but we won't have the date until the judge decides.
But we don't know if that's after June 5th or not. You know?
The date would definitely be after, because he can't modify the bond until after.
So he won't be able to get released from Grand Rapids until.
So I don't know what's going on in Grand Rapids. If his sentence is over in Grand Rapids, then they'll transport him to Eno County Jail.
Okay, that's how.
Yes, that's the
Okay.
goal.
So he's not gonna be let free.
No,
Okay.
no, we'll have to post bond on our file, which is what he can't. So we'll transfer to Eno County Jail first.
Yeah, he called her name. That's why I yanked him off.
No.
I don't say that about too many people I deal with coming, but that's what I'll say.
He's a very aggressive person. Like, he's not- I'm terrified. I can't. I don't have anywhere. I lost my house and my job because of him. And I have to have a C-section. I can't protect myself and my kids from him. So it's just given that he does have a backup plan tomorrow. He was trying to see if he could get out. So if that is the case, when would he be able to bond out? On June 5th?
No, so if we transfer first. So,
And then bond out.
yes, so are you on finally?
Can't do that.
So, if you were binding that, you'll be able to look up the name and sign up for it. And you'll get a message, a text message, anytime any custody status changes, okay? So if so you'll get a text saying he's been released from Grand Rapids, we'll go to you. If he goes, one second, if he goes on and he's no also be.
What is his bond, like $1,000?
No, his bond.
Wait, is court jail? But why do?
Determine if you're gonna go to jail or not. Or if you have to pay rent.
Wait, but why do they bring jail persons in here? The jail persons you want to see.
No, we don't want to see.
Why? Because they did bad stuff.
Yes.
Or they might have stole the bank. That's going to jail.
Or that, yeah.
Yeah, and then they might want him back.
I'm not sure, it doesn't show me in my system what the bond amount is. Are you?
How's he gonna get a PR bond if he doesn't have?
No, he does. I just don't see it. The court has, I don't see it. Have you been in contact with anyone from my office as far as a victim witness or a victim advocate?
Haley?
Haley, okay. So Haley can get you the paperwork of what that bond amount is.
She told me she was gonna be here today.
Yes, she is in juvenile courts today. So I know she was here this morning. I talked to her this morning. So I'm not sure she's just in court right now or what's happening. So she can get you paperwork so that you don't have to make a bond. Okay. And if he contacts you in any way, right, from jail, make police report.
Restraining order again, because, I mean.
So there's no contact order.
A PPO, because they denied it before he got.
Yeah. So there's no contact order. You can always apply for PPO again, absolutely. Yeah.
We can, we had some aside that the adults ate all the candy down in the candy dish. So, because we normally have candy down there.
Okay.
They took it off.
Thank you.
Yes.
What?
You ready to go?
Ready to go eat ice
Here, get your phone. Thank you.
Yes, of course.
Bye.
Bye-bye.
That's a nice house.
I saw.
I wondered if I left it here when I was.
Oh.
All done?
Till this afternoon. Right. 11,000, 13,000, 14,000, sorry. 16,000, 17,000, 18,000. All right. Okay, so we're gonna be doing this white line, okay? Go ahead and stand on this white line for me, just like this, feet together, okay? Take your right foot, come in front of your left foot, feel the toe. Want to do that right now? Feel the toe. All right, and then, no, just, yep. Don't tell us that. Give it a try. 7 times out of 10 stop. In hard time to do, okay? All right, so what we're gonna do is I'm gonna say that 9 steps. Feel the toe. And we're doing something like this, okay? 1, 2, 3, 4. So on until you get to 9, okay? When you get to your 9th step, you're gonna sort of do the small turns. And you're gonna do it again. 1, 2, 3, and so on. Okay? Okay, I'm sorry. Do you have any questions? Yeah, I want 9 steps and then I do like a full circle and tiny step. We're doing a small step and then you walk up another 9 steps. Okay, so again, it's gonna be beautiful like this. 1, 2, 3, 4. So on, we're gonna get to 9 steps. You're gonna do the small steps just like this. And you're gonna do it again. 1, 2, 3, and so on. And you get to 9 steps, okay? All right, do you understand my instructions? I don't think so. All right, go ahead, get it. You want to count out loud? Okay. 1, 2, 3, 4, 5, 6, 7, 8, 9. Series of small steps like this. Three, six, seven, eight. All right. Pushing modifiers that use liquid preliminary graph analysis upon a proxy piece action. If user does not as a proxy charge that removing charge, it is someone catching it with a penalty of up to $11. Okay? And we took a PBT for me. I mean, like, it's really good. Because I know that they can be inaccurate. Okay, so this is how on the body for representing the PBT. Because they can be inaccurate, yeah. Then under rest is our non-intoxicated. Going to turn the back and notice things like the frame, all right?
Doing great. Just got an email from Patty. And she's gonna put us in the record on the benefit pre-trial statement. I don't know if here. Sorry. Portfolio Recovery Associates, this is Michelle Lopez. Great honor. Do you know if our motion for summary disposition was also scheduled today or just a pre-trial? Sounds great. Hopefully I can resolve. Thank you. All right, come on. Okay.
So.
I'm like, you look familiar. Maybe that's it. So, okay.
I was also supposed to. Tell you that I forgot.
Okay.
Hey, why is it?
Have you guys run a preliminary exam with John Lee yet?
I haven't told, I haven't said anything yet, so
Oh, you haven't, okay, dang, right,
I don't know.
okay.
Yeah. I seen Lee, obviously, I seen Lee earlier, I don't know where he went, so.
Yeah.
Oh,
Hey, it's Friday though.
seriously, exactly. That's the good part.
Mm-hmm.
Oh, damn. Do-do-do-do-do. Okay.
Get a lot of.
Who does it? Who does it? Huh? Zeta. Zeta? I think have Zeta do that. Oh. In there? Twister. But you gotta have some kind of stuff to keep it twist. That's it. Oh, that's it. Oh, no, she's just done. Look at this. Well, I did. You know what I changed? Today. Now I got. Like, two. I got. Snap. I used to get that big thing like that. But we got two. That's what I was trying to do. That's champagne. Toast. Same stuff. Smell it. Body bad. 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 Smells good. And then over the US.
I did, I'm just gonna email a conditional dismissal for the defendant for signature, and hopefully we'll get back to you in the next 14 days. Thank you, have a great day. The clerk and the president, she doesn't need to stay here on that. Yeah, I think we should request, we want to have a better.
You writing something? Yeah, but he's. It's based on some of the stuff that there's some safety. And the judge said that we should. Side people. Sentencing, I don't know where my guy is. David.
Your lunch is here.
Oh, thank you.
So,
Yeah.
Jackson.
Uh-huh.
And Jackson. Well, I guess you didn't join her. Yeah. So Mr. Oak subpoenaed one of the LPD officers. While the city attorney accepted it, we don't know that that officer got it. I've been texting him, he's not answering me. Oh, hang on, I'm lying. He did not get yours.
You got another one?
Well, he said, I've just looked in Carpel and it says no, because I don't have them subpoenaed.
Yeah.
Yeah, so no, he did not get yours. So because he didn't get a subpoena, but he wants to ask for an adjournment, I have no objection to that. I understand why he wants to question that officer. And because they're all running together, and Swansea, because then he objects to that.
Okay.
But it's, I know this is such a rejection.
Okay, I will let him know.
Okay. And then we would just adjourn the CCW one too, just to run
Everything all together.
Get them all together.
Just a moment.
I need to know if there's something.
No, I don't even know if my guy's here. He left me a message about an hour ago that he was trying to take care of some SOC warrants before he came over here, and he said he was gonna be running a little late when he said he was at the FOC, and he said something about running a little late.
Yeah, we'll see him next week.
Oh, I was gonna say, he's not gonna-
Well, he thought he said he was gonna pay. He said he was gonna, I don't know, I was like, he said he was gonna pay to take care of it. I don't know if that's a thing, but if he
Well, I
said he was
guess,
gonna-
well, yeah, if you owe.
if
that's
you
what
have the
they're for.
money, yeah, if you have, and yeah.
You got enough to pay off what you owe, they'll cancel the warrant.
Oh, okay.
Do they? And Apple, isn't that a civil warrant? I don't know.
When you have a warrant. Yeah, if he's not here, I'm just gonna ask for, either adjournment or $40, so I can figure it
Yeah,
out.
he probably was still arranging on there. I worked in circuit court for years, but yeah.
I don't know.
Because eventually he'll show up on fire, we'll see that he's in custody,
Yeah.
but right now, he just went there and.
Yeah.
just taken into custody. He was really worried that he came here and he said they would know about the warrant, he would be taken into custody, so but he said, just need enough money to come to FOC. What's up?
I'm gonna try my computer. to see if I can update it.
Oh,
Back to home.
yeah.
Yeah, because my understanding that when you get to India, if you have a woman, even the court of love is gonna send stuff and say,
Yeah.
Well, we'll get a warrant here.
What's up, Lee?
Yeah, you still running your PE?
Yeah.
Oh, boy.
Yeah, your guy let me know his whole displeasure on whole walk down.
Yeah.
Yeah. Yeah. I had him before. He was in the, he had an LT here. Yeah. So he's up here a lot. A lot.
This is a higher level going.
You probably don't have it.
So.
When did you participate in transpire?
Yeah, maybe.
I was looking at it's last year, I thought that they were there. It was scheduled. I don't know when they did. That's what I said. I didn't know that. Yeah, that was a point. Sometimes
Oh, okay. I see. Yeah, I see why.
Mr. Oaks, did you need your client here for, just to reschedule?
Not to
Brought up.
reschedule, but I do want to address bond. I don't need him here to address bond, but I still would like to address bond.
Oh, yeah, we can still go on the record. 'Cause
Yeah,
we're gonna
yeah,
go on
for
the
sure.
record for this.
Yeah.
Also, can you look at May 28th? Because you're kind of the one that want to make sure your schedule is available.
May 20. Afternoon.
Afternoon?
Yeah. So I'm trying to figure out. Who it's- So, but, yeah, for the afternoon, yeah, we'll be good.
Okay. Because just looking at the, oh, I was trying to do it like the week earlier, but. We're thinking we might not need to bring up Mr. Jackson. I mean, we're just going on and doing a switcheroo, and you wanted to just address that, and so I think we might not. And then are the other ones Where are you at? on your ones?
They're all Jackson.
No, I know, but the other.
Oh, the one from this morning?
That one, and then don't we have sentencing?
Oh, yeah, sentencing. We don't know if he's gonna appear.
Okay.
Because he had an FSC warrant that he was taken care of. And Sarah hasn't seen him yet. So he may have been taken into custody. But we're ready on the, I don't know, we're done with this. I'm ready. What did I see? This morning.
On the prelim. He's
The prelim from this morning.
the attorney is here. So I realized it's flexibility that day. If we need to close the afternoon would be best at 28th, May 28th.
I can't.
You can't do 28th?
Ah.
Okay. Back to the drawing board.
Okay. Okay, so look at my computer up here, so I know we're not on the record or anything now, but let me, just looking at dates here.
Oh, right, my guys got a hold of me using Jackson for another court.
Oh.
They did let him go. He is on his way.
Oh, this is all great.
Yes, it is.
So what about June 5th?
Yes. We can do June 5th. I have it afternoon again. I have some that morning. And I got my son's high school graduation, but I suspect we won't be here until 7. We count on that?
Do you want a different day?
No. June 5th works. It works for you?
What?
June 5th. Yes, we can do June 5th.
Okay. All right, and I'll go let him know that we're ready.
Did you say what time?
Afternoon.
All rise.
You be seated. Ms. McComber, what case did you want to call next. We have the Jackson matters, the Dell matters, and we have Mr. Layton.
We can do the Jackson
Okay.
matters.
So there are 3 files and then 2 files on the Jackson matters. Let's call those. So we're on the record in docket 260075. 26000245. And 260074700471. And that's all people of the state of Michigan versus Cedric Jackson. And then we'll call the second co-defendant. Appearances for the record, Ms. McComber.
Good afternoon, Your Honor. Natalie Makeover on behalf of the people.
Mr. Oaks.
Mike Oaks appearing on behalf of Cedric Jackson, who's presently not in the courtroom, in anticipation of asking for an adjournment and to address bond. I am hereby waiving his appearance.
All right, and you'll make sure Mr. Jackson knows whatever we do here. Is that correct, Mr. Oaks?
That is correct, Your Honor.
All right, and we are waiving his appearance, Ms. McComber?
Yes, Your Honor.
All right, and then we're on the record in 260074 and 26000246. That's people of the state of Michigan versus Akias Jackson. Appearances for the record, Ms. McComber.
Good afternoon, Your Honor. Natalie Makeover on behalf of the people.
Ms. Wanji.
Good afternoon, Your Honor. Melanie Wanji from Mr. Jackson, who's at the council table.
And sir, you are Akias Jackson, is that correct?
Yes, sir.
All right, thank you. This is the time set for a preliminary examination on all 5 files. I think this was a motion for bind over and some other maybe some other testimony. Ms. McComber, how are we proceeding today? Mr. Oaks has indicated that they're requesting an adjournment. I'll tell you what I know about the case thus far. Mr. Oaks subpoenaed an officer to be here to testify. It appears that officer either didn't get the subpoena or has an answer to the subpoena. I don't know which one, but he didn't, but the subpoena didn't go through. And so we're stipulating to adjournment to have the officer testify and then to continue with the motion for bind over.
Yes, Your Honor, all that is accurate. I have been texting with the officer. He is available on the date that the court staff has found for the June 5th date, and is aware that he will be subpoenaed again. We'll subpoena him from our office too. That way there's no confusion.
All right.
I think that was part of the confusion as well.
All right. And so if both of you are involved in getting the officer here, there's no reason why the officer shouldn't be here.
Yes.
Is that a fair statement, Mr. Oaks?
It is.
Okay. Ms. Wanji.
Yeah, I've stipulated the adjournment.
Okay, so we have an agreement to stipulate to adjournment. I think we got a date. What date is that? So we'll adjourn to
June 5th at 1:30.
June 5th
1:30.
at 1:30 on all files. So that would be the previously indicated files of 26000471, 26000245, 26000075, and then Mr. Akias's files of 26000246 and 260074. All adjourned to June. So we'll do the same thing, but have the witness here at 1:30 on June 5th. Is that a fair statement, Ms. McComb?
Yes, Your Honor.
Ms. Wanji?
Yes, Your Honor.
Mr. Oaks?
Yes, Your Honor.
And that June 5th at 1:30, that works for everybody, because that's the scheduling issue here. That does work for everybody. Is that correct?
Yes, Your Honor.
All right.
Yes, Your Honor.
All right. So we'll adjourn to the June 5th at 1:30 date. I did receive the response to the motion for bind over that was submitted by Mr. Oaks, and I've read through it. I have both transcripts, so we'll continue past the witness's testimony. Did the people rest in that case?
Well, we were still on the cross of.
I just couldn't remember. Okay.
So No, we're done with our direct.
All right, and,
Pending any cross.
all right, and then pending crosses, and then the officer is subpoenaed by the defense, is that correct?
Not the one that's currently testifying.
Okay,
Well, it's currently testifying is Detective Darter. He's subpoenaed by our office.
right,
He's here, but the one that would testify would be called, well, either I'll call him as the last witness or.
all right.
I'll call him
And
as
what's the name of that officer?
Rob Olson.
Rob Olson. All right, with that understanding, we will adjourn to June 5th for the testimony, the finishing testimony of witness number eight or nine, I believe. And then we'll have Officer Olson testify, either called by direct and then cross-examined, or called by direct by the defense.
Yes, sir.
Anything else for the record in docket 2600-246, 2600-074? That's Mr. Jackson's file.
No, you're.
All right. So we've adjourned that to June 5th at 1:30. At 1:30. Listen to test. All right, that's all for the record in those two files. And then we're on the record still in 260075, 2600-245, and 2600-471. It's my understanding we are adjourning that to the same date of June 5th at 1:30, and Mr. Oakes has a motion in front of the court. Is that correct?
Yes, sir.
All right. Mr. Oakes, you may proceed.
Thank you, Your Honor. Your Honor, and with my client's case, I would like to address the bond. In his case, he has two bonds at $8,000 and one this court set at $200,000. The bond this court set at $200,000 is a carrying concealed weapon. I'd like the court to just take into consideration and reviewing decision on whether or not to address that bond. Is my client does not have a criminal history. My client has no prior criminal convictions. The allegations are that he was seen on camera with something in his hand that resembles a firearm. So we asked this court to take that into consideration. My client, out of this group of individuals charged, is the only individual who is incarcerated. He has family support that's evidenced by those in the gallery time after time at these court hearings. He does have a child on the way. So we asked this court to consider lowering the bond, and at the most extreme, if there was any type of concern of safety for the community, my client would be willing to subject himself to a tether. So we asked this court to bear that in mind in making a decision that could best secure the interests that this court has. And it's my position that that can be done outside of having a $200,000 bond.
All right. Let me make sure I have on 2600-075 a 3,500 10%. Is that correct, Ms. McComber and Mr. Oakes?
Yes.
Okay, that's the weapons discharge in the felony firearm and the carrying concealed weapon. And then on 2600-245, I have a 5,000 10% on RNC and retail fraud. Is that correct, Ms. McComber and Mr. Oakes?
Good. I guess my notes from our last hearing are that on both the 7.5 file and the 2.45 file, the court reduced the bond in those to 20,000 cash or surety, but there's a bond on the bond violation of 8,000 cash or surety for both of those files.
Okay.
The CCW file still remained at the 200.
That's the 200,000, and that's what the bond rec is coming in on. All right. I wanted to make sure. So on 2600-075, that is a 20,000 cash surety, and the 2600-245, that is a 20,000 cash surety.
Yes.
So this, I didn't recall the court changing the bond. So
That's the very, I mean, I think it's like the last 4 pages of the transcript.
Yes.
Okay.
On just those 2 files.
On just those 2 files, and then the bond violation was set at 8,000 cash surety. Those are what's my notes reflect.
Yes.
All right. Any on the motion on the 26-00471 motion reduce bond on that file, Ms. McComas?
Thank you, Your Honor. The people's position remains the same. Mr. Jackson was out on bond for what this court has heard the majority of the testimony from already on a shooting in an occupied house, with the argument that the people are asking to add on gang enhancement charges. While on bond, was caught yet again with another firearm, and this time with an AR style or assault style rifle. The concern that he would have continued access to weapons is high, and that there may be continued involvement with those weapons. If the court is considering lowering bond, I understand the co-defendants are all out. Each defendant has been assessed differently. I would note for the court, Mr. Orr is a co-defendant. He is in federal custody, but he is not being held on our charges. If the court is going to consider lowering bond, the people would ask that at a minimum, Mr. Cedric Jackson be ordered to have house arrest with the GPS tether. It appears that when he lingers outside of his house to hang out with friends, he ends up with firearms, and that is a great concern. There's still a concern that he would have access to firearms in the home, considering the allegations in this case of the firearms that were located that are tied to the shooting were located inside of his home. But ultimately those were seized. So if the court is going to consider lowering bond, we would just ask that he is to be confined to house arrest.
All right, Mr. Oakes.
Thank you, Your Honor. Your Honor, and I guess so we all clear here. He wasn't caught with an AR style rifle. He was seen on a camera system from a great distance with something that the people are saying loosely resembles said. So it's not a situation in which he was physically caught with a rifle and that was recovered off of his person. And I ask that if this court is going to consider a home confinement GPS tether, then his bond be adjusted on all files to a PR bond. And then he can participate with the home confinement GPS tether. It really wouldn't make much sense for his family to struggle to come up with roughly another $20-some thousand to bond with all these various bonds, even going through a bondsman, to then for him to sit home. So if he's gonna be on home GPS tether, we ask for a PR bond.
All right. Anything else from the people, Ms. McComa?
No, Your Honor.
All right. I have this crime. This was committed while the CCW and was committed while the defendant was on. So it was initially set asking for $250,000 at the arraignment. The third felony in 30 days. So what I'll do is because we are extending this out, but I'm not going to reduce it by that much. I'll reduce it to 180,000 cash surety with no home confinement or GPS. We'll set it at $180,000 cash surety, and then the other bonds will stay intact. So we'll reduce it for some lot, and mostly because this is getting to be so long. We're getting into June, and we haven't had a decision made on the case. So we'll go till June. It's set at 180,000 cash surety, and that's for the entire bond. And that doesn't include that. So I'm not placing a GPS or a home confinement on the $180,000 cash surety bond. Anything else for the record in 26-00471, 26-00075, or 26-00245, Ms. McComb?
No, Your Honor.
Mr. Oakes?
No, Your Honor.
All right. I will see everybody on June 5th for the continuance of the prelim. Thank you, everybody, for your appearance today.
Thank you.
Thank you, Your Honor.
Folks.
Then Ms. McComber, we have Bedell
Yes, Your Honor.
and we have Layton. Is that Miss,
He's not here yet.
has he been brought up?
No, he's not custody. He left, I talked to him about 20 minutes ago. He was, before he came here, he wanted to take care of a couple of FOC warrants in Jackson. Before he came to court. So he said he did take care of them, and then he was on his way, but he was.
All right, is Mr. Layton here?
John,
He's
downstairs.
Let's go get Mr. Layton and then we can do whichever ready to go on.
Can we talk, yes.
Yes.
We're gonna need extra.
Okay, for Mr. Layton.
No, for the capital. I literally, the young man back here was taking his phone. And his the whole time giving him death stare. So I don't know what's coming out of this, but you gonna need some.
It's like the fourth day with that.
Yeah, cause I told him, I don't know, the guy, he come in, I just happened to catch him, he's doing this.
Yeah.
To him, and this group's giving him the death stare all the time. That's why I asked folks, is there something going on? You know?
No.
Okay.
We may want to look at the
Yes.
videotape to see.
I'll let.
Yeah, we'll let the security.
Thank you.
Yeah.
Layton.
Yes, please.
Yeah. And then Ms. Donnelly, when Mr. Bedell gets here, we'll start the hearing and then you can.
Yeah, I'm hoping that maybe we can find a break, or maybe it'll end quick. I don't know, but yeah, I'm good. Don't worry about me.
That's the video that you recorded. You say it's coming.
Oh, yeah, it is. That's one of the counts.
Sure, but not.
There's 2 counts on it that we've added.
Absolutely.
This is the 3rd day of testimony. Believe me, we put a lot about it.
Like, this is day 3. You just weren't here for it.
If it's only from the defendant, you can say that?
Only if I ask him, it's hearsay. Right? I
Yeah.
mean, what would be the exception?
So, yeah, but we'll let security know next time.
Yeah, I
You might be right.
And
But that's why we're not security.
it does make sense to have, I think, probably to have.
I'm the worst person to do that. And so, so I always like, yeah, whatever, but it's good to have people who are cognizant of that.
He said, yeah, I don't know if you've seen some of these people before. Probably.
Probably. In other courtrooms.
Yeah. And so he's like, that's when he said he called me. So I'll make a note. So I'll do that right now. What was it, June?
You definitely take care of the extra security for that case.
What are they gonna do?
Oh, yeah.
Give presents. That's what they'll be.
I don't know.
Because this is just the motion for a bind over. We've had kind of the testimony already.
Yeah. Like,
And the officer's not going to be intimidated.
well, that just made our afternoon later. See, that worked out.
So
We're gonna get out on time today.
think of that. We deserve it.
Okay, that's fine. Well, I'm not gonna worry about the video.
Although I still need to reschedule almost 18.
They're not trying to.
No.
What did
So I
we,
couldn't ask.
all the other, the state cases.
Yeah, that back in the day, I was just started doing it. Yeah.
Well.
I might take that date. I haven't decided.
Yeah.
It is mom's birthday.
That's
It would
a
be
good
nice
one.
to give her a.
Yeah, that'd be a good one. And I think I'm off the following day with the conference. On Tuesday. But so it kind of worked out. And you hate to say that.
Oh, yeah.
but
That's fine.
It kind of worked out.
That's a quick trip though. When you fly out.
I fly out,
on Saturday.
so we'll fly out Saturday and we'll come back Monday night. And I'll see my dad on Sunday.
I wasn't planning on introducing anything. So.
I'm sure they have.
Are you planning on introducing the
So
In Colorado would be nice weather.
I don't know. Colorado's
If
kind of,
Officer Moses.
but it should be, it shouldn't be.
Is that north where in the state? I know it's kind of like a square.
It's kind of in the middle. Southern Colorado
We have to play.
is Grand Junction. It's not far from Boulder and Fort Collins, Denver, but it's still, it's kind of in the middle of the state.
Hi.
It is truly a long drive. As you drive west and you drive through, really it's agriculture. It's like, Western Colorado is all agriculture. It's not until you get to the heart of the city that you actually get to see the mountains.
My friend that was in Idaho, so she born and raised here, and then she moved there and brought her father. And he passed away last fall, and so, and he's cremated, so they're bringing the ashes back this summer in July, to the UP with some of the friends who have like 350 acres and whatever they're gonna do. I don't know.
You did also.
But they're driving, and so they
No, I'm fine. I
bought
just want to make
like
sure.
a travel van, so they're gonna drive.
So they're driving west to east.
Yes, but they're going north, the north.
Okay.
So,
Are they getting into Canada?
no, they're staying in the US, but she's like, we want to do something in every state, but it's the same thing. So she's like, one of the things I want to do is in every state find a restaurant that Guy Fieri went to, like put that diner, drive-ins and drives or whatever.
What if we get the report, right?
And so I'm like, okay. And then she's like, we're gonna buy a scratcher in every state. And she was trying to do something like that for every state. Like, okay.
We went in late May, we went from Denver to Minneapolis, taking that same route, but the northern route. So we went through the UP and then we went through the top of Wisconsin into Minneapolis and then back through Wisconsin. And it was cold in Minnesota on the north. I mean, it was like 40 to 50 degrees in that. So it doesn't get warm in the northern, in our northern states to like, I think June, to the late June.
Right.
It really doesn't. So it was a cool drive. I'd never been to some of those sections before, but I was surprised. I was kind of surprised how cold it was in Duluth. In Duluth, I remember Duluth, Minnesota. I'm like, this is cold.
Yeah.
This is cold for this time of year.
Yeah. Yeah, on the way back, they're gonna go the south way back. So, but she just was, I need something else. I'm like, oh, you're gonna hit the big ball of twine, you know, like whatever. She said, well, yeah, but she just wanted something that, like, we'll go to like the capital of every state. I don't know how that would work out. That's us.
It's another day in district court.
Two more weeks of soccer.
Potentially, but I am.
Do you see all their games?
Not all.
Plenty.
I do see a lot, yeah. And I don't know soccer. Like, I can follow what's going on. Like, I don't know rules. I don't know.
I'm
better with
less
hockey than
on soccer. I know the hockey rules, but I'm even then sometimes like blue line rules or those they kind of confuse me more than anything.
Yeah.
But I don't know soccer that well, but I've watched a lot of soccer.
But it's, I mean, in a way, it's like they're the same.
Yes,
it's
they
just
are.
one's on ice and one's not on ice.
Did you get voicemail?
So
I did.
obviously soccer's slower.
Talk to her and she
Hockey
said,
is, but
My favorite is
What's my
your
fiance? So she bought
nephews are a little older.
and I was like,
I have a 10th grader and a
but it was at y'all's house. She's like, yeah.
My favorite is when,
So-
because when I watched my nephew, they all just ran at the ball. Nobody's staying in their position, nobody's just, everybody's running.
Oh, yeah,
everywhere.
but they started that way. The youngest one, he was the kid, you know, when his first year or whatever. He's out on the field picking all the dandelions
Yeah, I
and then
know.
twirling around. And I'm like, oh my gosh, like, look at the ball.
It was, it's kind of fun, parents, there are parents who take every game. It's really fun to watch, like a kid at 5 years old play soccer and a kid at 14 play soccer.
I know.
Because it's completely different. One's into the game, the other one like when you take a 5-year-old, they're playing in the goalkeeper with picking dandelions perfect. It's just, you know, the parents are out there helping the kids. The kids are not paying attention because, you know, we had the coach's son came over to him, he's coaching, he's making sure that it looks like the semblance of a team because none of the players are. And his son comes over and he says, like, I'm done. And he just sits down, I'm done. He's like, you can't do that. You've got to go take your positions. Like, no, I'm tired. I'm done. I'm just gonna sit here for a while. And so we all joked about it when he was 15 and now he's really into it. He's like, you're like, you know, when you were 5, you just go to your coach and say, I'm done. It's like, I can't imagine doing that. I'm like, yeah, you can't imagine doing it.
Yeah, that the youngest one now, you know, yeah, he's all over the place. The older one, even more so, he took the being a ref training. So he even is a center ref. Center ref, you know, he's paid a little bit more to do that one. And so, yeah, he does, you know.
You have to be so patient because you understand, you're kind of a teacher. Making sure the parents don't get all crazy.
It's the parents that are.
Because they can go nuts.
Yeah.
Thank
you.
That's fine, and you know,
Club stuff, it's not even like school stuff.
Yeah. If you want to call
All right, this is Zachary Layton, is that correct?
Yes, sir.
All right, so we're on the record in docket 26-00870. That's People of the State of Michigan versus Zachary Layton. Appearances once again for the record, Ms. McComb.
Good afternoon, Your Honor. Natalie Maycomber on behalf of the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Zachary Layton.
And once again, you are Zachary Layton, sir, is that correct? All right, thank you. This is the time set for a preliminary examination today. Ms. Maycomber, how are we proceeding?
Thank you, Your Honor. It's my understanding that we will be running the preliminary examination in this matter.
All right. Is there anything to come to the court's attention before we start the preliminary examination? Ms. Maycomber, we're going to invoke the sequestration order at both sides' requests, but I, of course, don't know the case as well as you do. So if you see anybody come in who shouldn't see another witness testify, just let me know and I'll make sure they're removed from the courtroom. So we do have a mutual sequestration order.